Maybe yours. But item number 43, my lord. Condemn marriage become infructuous, my
Order has been complied with.
my lord.
Just 1 second. Item 43, you write, Mr. PJ Cycle and a counsel for the petitioner submits that the order of the court has been complied with, and therefore this contempt case can be closed. In view of the submission made by the petitioner's counsel, this contempt case stands closed.
Oblige.
May I please, your lordship? Lordship, with the consent from the other side, I beg to mention item number 18. Lordship, in this matter, we are led by senior counsel Kane Chaudhary. He is not, he's out of station, lordship. Matter may be passed over for a day.
I only pays for date. I am to respond.
That this court is not accepting. Somebody asked for Passover and other persons asked for fixed date. That is creating problems. We'll adjourn it for 2 weeks.
Much of that.
Learned counsel for the respondent submits that the arguing counsel, Mr. Kane Chaudhary, is out of station and therefore this admission hearing of this matter be adjourned for 2 weeks. Mr. N.J. Gogoi, learned counsel for the petitioner is present.
I am for respondent. He's the.
Acha. Then it has been given reverse. Okay, Kane Chaudhary for petitioner.
Yes, my lordship.
Acha, petitioner. Yeah. Mr. N.J. Gogoi, learned counsel for the respondent number 3 is present. In view of the request made by the petitioner's counsel, admission hearing of this matter stands adjourned for 2 weeks. Yes.
Highly obliged.
May I please, your lordship? My lord, I beg to mention item number 51, my lord. It is, my lord, infructuous, my lord. The order has already been complied with.
Item 51.
51.
Mr. S.A. Ahmed, learned counsel for the petitioner submits that the order of this court has been same order, huh?
Obliged.
Closed. Same,
May-
I go to law.
May I please, your lordship? Lordship, item number 11, lordship. And pass over for the day after 2 weeks, lordship, can it be lordship?
Item number 11,
11, lordship.
on the prayer of Mr. F. Hawk, learned counsel for the petitioner, this matter stands passed over for a week.
Lordship. Obliged. Obliged.
May I please, your lordship, for listing of a repetition related to retirement benefit, lordship. Not listed on 26/8/22, lordship. Thereafter never listed. Can it be before vacation, any date, lordship?
Before vacation will be difficult.
Then
Why-
after vacation, any date, lordship.
You choose a date,
Lordship.
you fix it.
May I please, I beg to mention item number 21, my lord. Kindly pass over the matter for the day, my lord. 21, my lord.
Item 21.
Yes, sir.
On the request of learned counsel for the review petitioner, this matter stands adjourned for a week. List accordingly.
Obliged.
May I please, your lordship? Lordship, in respect of item number 10, so lordship, it has been wrongly listed before this honorable court, my lord. So lordship, kindly give the direction to the registry, list the matter before the appropriate court, lordship.
Why it has been wrongly listed?
So, in earlier occasion, the matter has been listed before the Justice Juthang Kumar court, lordship.
No,
Where
that
the
is not a.
matter, already the matter relates to power, no, my lord. So,
No, you wait, we'll see once the matter is called up.
yes, ma'am.
You'll be present, yes.
May it please this, my lord. Now, in respect of item number 27, my lord, I am filing the affidavit during the course of the day. And as such, my lord, matter may be passed over for the day. I have taken the consent of the other side, my lord.
I'm for the petitioner.
No objection.
No objection.
Mr. T. Chakravarti, learned counsel for the respondent number 2 submits that counter affidavit on behalf of his client will be brought on record during the course of the day.
My lord.
As such, this matter be taken up again after a week. Since the prayer is made with the consent of learned counsel for the writ petitioner, same stands allowed. Register to list the matter by tagging the counter affidavit of respondent number 2 with the record of this case.
And deeply obliged.
Obliged.
May I please, your lordship? Lordship, I beg to mention item number 8. So matter may kindly adjourn for 1 week, my lord.
Item number 8.
8, man.
Yes, what do you want?
Adjourn for 1 week, my lord, kindly.
You are for the petitioner.
Yes, ma'am.
Your name, please.
R. Bora. My name is not there, my lord. I am on behalf of AAR Karim, my lord.
On the request of Mr. A.A.R. Karim, learned counsel for the petitioner, this matter stands adjourned for a week.
My lord, item number 23, 24, and 25, my lord, similar matter, my lord. In these 3 matters, I am led by senior counsel, Mr. K. N. Chaudhary, my lord. He had to be out of station today, my lord. Any date, my lord.
After vacation, after vacation. No, that is a
Well,
problem.
only adjourn for today.
That
my lord.
is really creating
Lordship
problem.
may not like to
Council
observe.
will be out of station, in station.
My lord, my
You
lord.
can't ask the court to wait for that.
My lord,
Then you
review
have to
petition,
go
that
by,
is why, my lord. Review
Huh?
petition, that is why.
sorry,
Review petition, that is why, my lord.
then you argue it, we'll hear it today,
Some other.
some other day, all right. Prayer for adjournment has been made in these matters 23, 24, 25 on the ground that the arguing counsel, Mr. K. N. Chaudhary, is out of station. Since the prayer is not opposed, same stands allowed. Registry to list these matters again after the ensuing summer vacation. Yes,
May it please your lordship. Lordship, I beg to mention an item for listing of a writ petition. Matter pertains to illegal termination of 771 contractual employees of ASTC. They have been terminated, lordship, without prior show cause notice and without affording of being heard, lordship.
Hmm.
Lordship may taken up the matter on Wednesday.
motion,
Yes, lordship,
yes.
obliged.
Lordship, I may be allowed to move for admission hearing. The matter pertains to the industrial dispute. It was last posted on 18/7/2022.
After summer vacation, yes, put a date, after summer vacation. Yes, call.
Top of the list, I think 1, 2, and 3. Please, Lordship, kindly adjourn the matter for the day, Lordship.
Here for whom?
A Gaya.
No, the petitioner's counsel was absent.
Lordship, I am appearing in item number 3 only.
What are these matters? These
Lordship,
cases will not be adjourned. I'm so sorry.
Lordship,
It's the
that-
top of the list.
Lordship, that in this item number 3, we are challenging that initially, Lordship, challenging the disciplinary proceeding.
Hmm.
Petitioner earlier approached this honorable court, honorable.
All right,
court-
item 1 and 2, you write none appears for the writ petitioner when the matter is called up. The learned CGC is present, learned CGC, Miss, you're there? Who's there?
1 to see the thing.
1,
1,
2, 1 and 2, Miss A.
A.
Gayan is present on behalf of the official respondents. This matter pertains to the year 2011 and record reveals that the petitioner's counsel was absent even on the previous occasion. In view of the above, this court is of the opinion that due to long lapse of time, the writ petitioner is not keen to pursue this matter any further. As such, this writ petition stands dismissed for non-prosecution. Same order in item 3 as well. Yes, give item 3. Yes,
Lordship, that item number 3, that any other hearing that initially petitioner approached this court, Lordship, and challenging the disciplinary proceedings. And that this honorable court remand back the matter to the department to pass a speaking order. Thereafter, respondent has passed the speaking order. But we again agreed by the speaking order, Lordship, approach this honorable court. That is the fact of
no,
this
no, but
case.
what is his grievance?
The grievance is that with the disciplinary proceedings was initiated, the grievance is that he wearing some badge, Lordship, which is not permissible as per the stand of the respondent. That is the issue, Lordship.
You argue your case.
Lordship, that can it be taken up that any that, Lordship?
Top of the list matters. not-
Actually, Lordship, that Mr. Muzumdar is
I'm
conducting
so
the
sorry,
case.
I'm so sorry. It'll not.
Lordship, I will file a written argument in the meantime.
We'll take it up after 1 hour. That's all I can do for you. Top of the list matters, it has been notified, there will be no adjournment.
Lordship.
Yes. At 12.
Item 4.
Well, a similar prayer, well, can it be after some time? Well, actually, I'm not out of the brief, my lord. I will have to go through the file and
All right, at 12.
end of the list, my lord, if possible.
No, no, at
Yeah,
12.
After some time, after. some time.
Yes.
On motion item 5. Item 5.
Second call after motion. Call it again. Well, ready now.
কি করবেন?
Here notice may be issued against the order of penalty.
Where is the order of penalty?
Page 94,
Page?
94, and here 20. Relevant lordship, you will find that page 96.
Take down. In this writ petition, the order of penalty of reduction to lower grade within court suburb, reduction to lower grade within court. Date imposed upon the petitioner by order dated 26/11/2022 has been put under challenge, full stop. I have perused the averments made in the writ petition. Issue notice returnable in 8 weeks.
I pay for all the
Mr. B. Gogoi, Learned Standing Council, Health and FW Department, appears and accepts notice for all the respondents as such. No formal notice is required to send in this case. Extra copies of the writ petition will be furnished to the Learned Department Council within a week from today. So as to
Bless you.
enable him to obtain instruction.
Well, this is regarding my commission appointment, my lord. Her husband died on 23/11/15. She applied for and she was selected. And that is my lord, kindly see my lord, page 15.
Yes, what is your instruction?
The SLC lordship considered her case because of lack of vacancy. Her candidature was rejected, lordship. It was dated 16/8/2022.
So
The
then,
SLC's meeting held on 31/12/18.
and what is 16/8/2022?
16/8/2022, lordship, we have been intimated by that letter.
Can you?
16/8/22. But, question not
So,
given.
Mr. Rashid will close it. You challenge that.
No, they
Your grievance was it was not considered.
or not
You have
considered.
considered and rejected.
District level consider I was selected, but state level, but copy board you could send to.
If your lordships comes to
Check
page,
that.
Page.
lordship, I am placing it before your lordship of the writ petition. Page
15.
Page 26. This is the letter written by the petitioner herself, lordship. Second paragraph, fourth line. My appointment on compassionate ground, but the SLC have no requirement of any post for my appointment and rejected my petition. From her own application, it reflects that her candidature was considered by SLC.
8 November.
So that was the direction passed by this honorable court in the earlier writ petition.
We also file earlier petition that was not, and also a contempt petition.
No, after 7/11/2022, what action has been taken? There is some order passed in the.
Yes, my lord, that is in contempt petition, my lord.
Yes,
But,
sir.
my instruction is nothing. Nothing. My instruction, my lord, I have taken. my lord.
Yes, but this direction is in the contempt case.
Yes, finish with-
Whether they are not raising this question, but can a direction be issued in a contempt case? You have to follow it since you are not questioning this order.
Lordship, while considering the SLC to take note the provision of the
you-
DLC in the event the recommendations of the petitioner was considered by the SLC in any of its earlier meeting at page 24, Lordship, page 20, has your Lordship got it?
Page?
Page 24, this is the order passed in the
Yes,
contempt.
That is in front of me, yes.
That para 6, no, it's a clause 6, Lordship.
Hmm.
In the event the recommendations of the petitioner was considered by the SLC in any of the earlier meeting, the result thereof be communicated to the petitioner. And in such event, there would be no requirement to place it again before the SLC. So it was rejected, Lordship, earlier. So the question of again placing it before the SLC doesn't arise. But regarding this communication part, Lordship, that is,
This is the order of the earlier petitioner.
yes, Lordship.
Yes.
And it was
Yes.
considered by the SLC. According to,
So let it be listed before the appropriate bench. Let the honorable judge pass an order. Because I'm unable to deal with this matter because the direction passed in the contempt case appears to be running counter to the direction passed in the main order.
as we, if your Lordship, the direction passed in the contempt case is 7/11/2022. And we were intimated by letter dated 16/8/22. Because of that,
16/8/22.
because of that, Lordship,
This was not brought to the notice of the court.
at that time, Lordship, was because it's 7/11/2022, we were unable to draw.
All right, you take down, heard Mr. A. Rashid, learned counsel for the petitioner, also heard Mr. H. Sharma, learned additional senior government advocate Assam appearing for the official respondents. First up. The husband of the lead petitioner, namely late Satish Chandra Das, died in harness on 23/11/2015 while working as a master role worker under the. He was working as master role worker under
And then this is
PWD.
under the PWD. H. K. Sharma for respond number 2 and 4 and Mr. R. Dhar learned SC PWD for respond numbers 1 and 3. They died on 23/11/2015. Thereafter, the petitioner had submitted an application for appointment on compassionate ground. First up. While letter dated 9/7/2017, the DLC of Gwalpara had forwarded her case. However, the SLC had rejected the prayer of the petitioner due to want of vacancies on 31/12/2018, which fact was communicated to the government, to the office of the learned government advocate. It was communicated to whom?
The letter is before Lordship, the government advocate, Lordship.
Government advocate Assam, wide communication dated 16/8/2022. However, in the meantime, the petitioner had approached this court by filing writ petition number. The writ petition bearing WPC number 1783/2022. For consideration of her case by the SLC. Full stop. The aforesaid writ petition was disposed of by order dated 10/8/2022. Inter alia, providing that the case of the petitioner be placed before the next available meeting of the SLC. With a further direction upon the SLC to consider the recommendation made by the DLC.
SLC DLC.
First up. It was however mentioned that if the case of the petitioner has been considered by the SLC in any earlier meeting, the result thereof be communicated to her, in which event there would be no requirement to place her case again before the SLC. Full stop. Alleging willful disobedience of the aforesaid order passed by the court, the petitioner had filed contempt case bracket C bracket close 608/2022, which was disposed of by the learned single judge by order dated 7/11/2022, with a further direction that the case of the petitioner be placed before the SLC in its next meeting. Full stop. In its next meeting within 3 weeks. Full stop. The instant writ petition has been filed by the same petitioner, renewing her prayer for issuance of a direction upon the SLC to consider her case for appointment on compassionate ground. Full stop. On the basis of the order dated 10/3/2023, Mr. H. Sharma, learned additional senior government advocate Assam, has obtained instruction and submits that the case of the petitioner was considered and rejected by the SLC way back on 31/12/2018. Therefore, however, the order dated. However, since the government advocate was not aware of the said decision, the orders dated 10/8/2022 and 7/11/2022 were passed by the learned single judge without being aware of the earlier order. Full stop. Full stop. Mr. Sharma submits that since a further direction has been passed by the learned single judge in a contempt case, and that too without being aware of the decision already taken by the SLC, a conflicting situation has arisen which would require appropriate resolution. Full stop. Mr. Rashid, learned counsel for the petitioner, has also agreed to the said proposition, which will require resolution in an appropriate manner, for which the matter be posted before the learned single judge who had passed this order. Mr. Rashid, learned counsel for the petitioner, has also agreed to such a request. In view of the above, let this matter be listed before the Honorable Single Judge, bracket, Honorable Mr. Justice L.S. Jamir, for appropriate orders.
Whether your lordship will keep that the instructions.
You take it back.
Lordship.
You get a clarificatory order from them.
My lord.
I cannot tinker with the order.
May it please your lordship.
Yes.
Well, this petitioner before your lordship, my lord, he was appointed initially as a casual worker in the court establishment, CJM Court of Nagaon, my lord, in the year 2001. And on 12/6/2001, and on that day itself, he was transferred to Hujai. Thereafter, my lord, he was working on different capacities therein. And on 31/8/2015, an order was notification was issued by this honorable court, registry of this court.
So petitioner was discharged in 2016.
Then he challenged this discharge order, my lord, during the pendency of this case. When he was discharged, he challenged it. But during the pendency of that particular petition, out of that 7%, 3 were regularized following a notification issued by the registry of this court. That notification dated 31 August 2015 at page 31. Then he filed another writ petition. Then during the pendency of both the writ petitions,
following this 31/8/2015 notification issued by the registry, three persons were regularized. Then the selection committee held, my case was not regularized. Selection committee held that since the matter is sub judice, we cannot consider the case. And on this, my lord, the learned single judge here, my lord, dispose of the earlier set of writ petition and held that it cannot be. Even though the matter is sub judice, there was no stay, there was no order passed by this court.
Where is the order of the?
Yes, my lord. That is at my lord page 33.
Page 33.
Yes, my lord. Starts from page 33. A relevant portion, my lord, lordship will find. At page 38 onwards. my lord. May I read?
Yes.
Page, paragraph 5 onwards. Situated thus, we required the respondents in the establishment of CGM Nagaon to provide the information to the court as to why three of the casual employees who were discharged by the order dated so-and-so have in the meantime been regularized, leaving out the present writ petitioners. In response thereof, Mr. UK Nair, learned senior counsel for the respondent 2 to 5, has referred to the minutes of the selection board meeting held on 2011-2018 in the office chamber of the learned CGM Nagaon. A perusal of the minutes of the selection board in paragraph 4 thereof makes it discernible that the cases of the two writ petitioners, Hiranya Hazarika and Jiten Boda, were not taken up for consideration for their regulation, inasmuch as the two persons had instituted the writ petition being number so and so and so, which was pending at the relevant point of time. And accordingly, the selection board took a view that the matter is sub judice and therefore their claims cannot be given a consideration. In this respect, we have also gone through the order dated so and so passed by this court in repression so wherein there was an observation that it is also made clear that in the event of respondents are going to consider regulation of workers, the case of the reputation will also have to be considered. This was not followed.
So
Then
now you are aggrieved by what?
now after this judgment, my lord, my case was objectively considered and rejected because of I am overaged. That cannot be. On 2 dates, my lord, 2-3 dates are important if I can say also, my lord. 31st/8/2000.
So then we'll issue notice at this stage.
Yes, yes.
Yes. I heard Mr. S. Shumwal on counsel appearing for the writ petitioner, assailing the order dated
My lord did find at my lord, page 42. Annex 10.
order dated 21st January 2023, by means of which his prayer for regularization in service was rejected. Page
Sorry. I'm so sorry, my lord. Annex 9, my lord. Sorry. Not 10, Annex 9.
29th December 2023, by means of which the prayer of the petitioner for regularization prayer of the petitioner for appointment in any post has been rejected on the ground that he is overaged. The instant writ petition has been filed. I have perused the averments made in the writ petition. Issue notice of motion returnable in 6 weeks. Who is appearing for whom?
Respondent 1, lordship.
Mr. A. Chakravarti, learned government advocate Assam, accepts notice for respondent number 1.
Lordship, I am
Mr.
appearing
P.
for
Nair,
lordship.
learned SC Finance for respondent number 2. Mr. H.K. Das, learned SC GHC for respondent numbers
3 to 7.
3 to 7. And Mr. H.K. Das, sorry, sir, respondent numbers 3 to 7. As such, service of notice is deemed to be complete in this case. Extra copies of the writ petition be furnished to the learned departmental counsel, so as to enable them to obtain instruction. Let this matter be listed again after 1 weeks,
6 weeks.
by reflecting the name of learned counsel for the respondent in the cause list. You see, Mr. Chumwa,
My lord.
there are some problems which sometimes cause difficulties for the litigants.
Right.
That is why you are required to be a little more focused. His discharge from service order has not been set aside by the learned civil judge, correct? That order has not been set aside. So his discharge is affirmed. Today, the legal position is his discharge from service does not stand interfered with. So the question of regularization today does not arise. The question will be only of fresh appointment. So the fresh appointment, they said, can't be done because he's overaged. They are correct. So now you know which way you are heading. We are just mentioning it to you so that you are not caught unaware. This is a clear case where you have to seek a review of the order. Unless his discharge order is set aside, how can he be regularized? He cannot be appointed without an advertisement unless he fulfills the conditions for recruitment. This is for your food for your thought. We are not concerned. But see how needless complications are created. Somewhere somebody fails to apply. And as counsels, you have to point out these things, even to the honorable judge who is dictating the orders. The judges are under enormous pressure.
Earlier round of litigation, I was.
That is gone. Whoever,
Yes,
you means it is
I
not
have to
possible.
solve that. I have to solve that. Yes.
That stage is gone. Technically, he cannot be regularized. That matter is over. That prayer has been declined by the learned single judge by necessary implication. So it is a fresh appointment. Fresh appointment cannot be made unless he fulfills the requirement of the rules. So if he has been found to be overaged, what can be done about it? All right, next matter, please. This is not a comment on the outcome. of this case,
I appreciate, I have understood.
But,
I bow down.
we don't want to be
Lordship, we don't want to be critical, but pointed out
But
the,
we have to point out these things. What is the point after 3 years if these points are raised? By that time, it will be even worse. So as counsels, you have to apply your mind and see what is the best you can do. Otherwise, there will be difficulty. You look at this man, if he gets to this answer after 3 to 4 years, what will remain for him? What will remain for him? Sometimes the state councils may also not be able to highlight these points.
yes.
But the fact is, this order of discharge has been affirmed. Yes, next matter, please. Okay. Who's the counsel? None appears for the writ petitioner on call. Mr. R. Dhar, Lanet. Is present. Since the petitioner's counsel, you are there?
My lord, I apologize for the inconvenience. My
No, no, it's all right. What is the problem here?
the problem here, my lord, we.
You wanted this matter to be listed, your junior wanted to be listed before
No,
Justice
Lordship,
Michael
may-
Gautam Kumar.
Lordship may consider.
Why, from when this facility is being given to the bar, that you can decide which judge the matter?
Yes,
to
yes,
be-
yes, I apologize.
Why
for
you
that.
want it to be listed before Justice Michael Gautam Kumar?
My lord, the fact.
Anything special?
No, my lord, nothing.
Share with us, the others can also
No,
get.
no, my lord. The some other matter is my lord listed, my lord, that I assume, my lord, that
Huh?
it's industry and my lord. So, my lord, some similar matter
Hmm.
has been listed therein. The lordship may consider, I do not have any, my lord.
No, I'm trying to understand, your junior made a mention that this matter should be listed before a particular judge. Is there any valid reason?
No, my lord,
There is no valid reason.
no, my lord, only that, I assume that this matter, my lord, my lord may be posted in bench for, I assume, my lord, it is a
No,
bench
because
for.
you see, unless there is a reason, we can't pass these orders.
My-
This before such and such judge. this
My-
Before such and such judge.
My-
If you want, I can say that not before me.
No, my lord, only for bench for, I assume that, my lord,
This
this
is not
matter.
bench for.
The lordship may consider, lordship may take up
Yes.
this matter, my.
Yes, what is it?
My lord, the fact here in this state, my lord. My lord, these petitioners are the proprietor of, my lord, some powerloom industries, my lord.
Hmm.
The fact here in this, my lord, they were producing, my lord, traditional items, the handloom products in their, my lord, in their industries. And my lord, and from the very inceptions and
Acha, so you are saying this is a civil bench 4 matter.
civil bench 4 matter, my
Well,
lord,
then
that I
say that.
assume, my lord, that I assume, my lord, I'm not,
Oh, then you should
I
have
don't
said
know, my
that.
lord, whether I'm.
Anyway, Mr. B.K. Das, Learned Counsel for the petitioner submits that This matter pertains to civil bench 4 and therefore it has been wrongly listed before this court today. Registry to examine the matter and list this case before appropriate bench. Any urgency?
No, my lord, as per-
Next week?
Next week.
In the next week. You are appearing.
I am repeating, but this case is entrusted to Povito.
No, it will be entrusted to you. Why should it be? Ilanet CGC, Mr. AK Datta is present on the other. All right, then it should go. You should have said that in the beginning.
My lord, he has.
All right.
Obliged.
You have got the records, Mr. Sharma?
Record lordship, they have sent the sheet, the Vivavusi sheet, where is, if you're. One, two, three, four, five, six, seven. His name appears in the seventh column, lordship, seventh line. Next to the number 5 given to Zunmoni Das. No marks is given.
None appears for the petitioner. Mr. H. Sharma, learned additional senior government advocate Assam is present. In terms of the order dated 31/5/2023 passed by this court, Mr. Sharma has produced the relevant extract of the record pertaining to the attendance of the candidates for the interview. Full stop. A perusal of the said record goes to show that the writ petitioner, besides some other candidates, were not awarded any marks in the interview process, thereby prima facie indicating that the stand of the state that the writ petitioner did not participate in the interview process is correct. Full stop. However, since the petitioner's counsel is not present today to respond to the above position, this matter is directed to be listed again in the next week for motion. Mr. T.C. Chutia, learned, you are for whom? Learned Standing Council Seva is present. You take it back.
Lordship.
And we'll see next week, let him come.
Lordship.
May it please your lordship.
Yes.
My lord, the health department in government of Assam issued an advertisement for filling up the post of ICU technician, 49 numbers of posts, my lord. And the requisite criteria was that the candidate should have high secondary science and a diploma in ICU technician. Now, my lord, the petitioners are agreed because respondent number 6 to 10 have been appointed as ICU technician, but they did not possess the diploma in ICU technician on the last date of submission of the application. Lordship will kindly come to the advertisement, my lord.
Yes.
Lordship will find it at page 37. And my lord, the requisite qualification, lordship, at page 38, serial number 37, page 38.
Yes.
Serial number 37. ICU technician, HSS-LC science or equivalent with diploma in ICU technician course from government recognized institutions. Has your lordship got it? Page 38, serial number 37. Then lordship. Lordship will kindly come to page 42. Annexure 5. The last date of submission of application was extended till 28 February 2022. Down below, my lord. This for the general financial, then last date till the Assam Tribune Censor is extended here to up to 28 to 2022 midnight. Last but one line, my
So you say that as on 28/2/2022, the private respondents did not possess.
Yes, I'll show from the documents, my lord. Now, my lord. The select list, we file a writ petition, my lord. There is an order of your lordship. Lordship kindly come to page 68. There is an order of your lordship. Well, before going to the select list,
Yes, page 68.
page 68, your lordship's order.
Yes.
It was moved, but on the preceding day, they published the select list, my lord. So it was withdrawn and we have filed this press release petition, telling the select list. Now,
So
lordship-
as in, any appointments have been
Yes,
made?
yes. I am praying for notice and so their appointment shall be subject to outcome of this writ petition.
My lord, their grievance is mainly the two grievance. One is that, my lord, on the last date of submission of application, the private respondent did not qualify. My lord, just now I have obtained telephonic instruction. They will send me the corridendum also, my lord. The last date was extended, my lord. The last date of submission of application was 8/4/2022, my lord. 8/4/2000. It is from record, my lord. So they will send me the corrigendum, my lord. 8/4/2022, my lord.
All right.
So,
So-
and regarding the second allegation, my lord, that they are not having the background of science, my lord. My lord, there are two advertisements at
So
page.
we'll issue notice, you file your affidavit.
Yes, my lord. At page 35, I may clarify, at page 35, my lord, serial number 7, my lord, there it has been specifically mentioned, diploma/certificate in ICU technician from government recognized institute. So science is not mentioned. And total post was 49, 47 posts were advertised by DSS and 42 posts were advertised by DME. In respect of that two posts, my lord, that science condition was stipulated.
Same health department.
But in respect of the 47 posts, the science background, that stipulation is not there in the advertisement itself, my lord.
File your affidavit.
Yes, my lord, I will file my
But Mr.
affidavit.
J. Patwari, learned counsel appearing for the writ petitioners, assailing the selection and appointment of respondent numbers 6 to
10.
10. As
ICU
ICU technicians under the
Health department.
Health Department, Government of Assam. The instant writ petition has been filed inter alia contending that the said respondents did not fulfill the requirement of the advertisement notice by possessing a certificate
Diploma in ICU technician.
of diploma in ICU, diploma of ICU technician course from a GOVT recognized institute as on the last date of submission of applications, which according to the writ petitioners is 28/2/2022. Full stop. Mr. Patwari submits that since the respondent numbers 6 to 10 were ineligible to participate in the selection process, hence their selection and appointment is vitiated in the eye of law. Full stop. Mr. D.P. Bora, learned standing counsel, Health and Family Welfare Department, Assam, submits that the last date of submission of application had been extended till 8/4/2022. And there is no mandatory requirement of the candidates of possessing any candidates being from this science stream
Science stream.
for being appointed as ICU technicians.
In terms of the advertisement.
In terms of the advertisement notice, first of the learned departmental counsel has however prayed for some time to place those facts on record in the form of an affidavit. In view of the above, issue notice of motion returnable in 6 weeks. Since Mr. Bora has appeared and accepted notice for respondent numbers
1 to 5, my lord.
1 to 5, no formal notice is required to be sent to the said respondents. Extra copies of the writ petition, requisite in numbers, be furnished to the learned departmental counsel so as to enable him to obtain instruction and file affidavit. Writ petitioner to take steps for service of notice upon respondent number 6 to 10 by registered post with AD within a week from today. Hard on the prayer of interim relief. Since the petitioners have already been appointed, it is hereby provided that the appointment the validity of the appointment of the private respondents shall be subject to the outcome of the retribution.
Obliged, my lord.
ICU फाइल में आज बैकग्राउंड और ICU टेक्नीशियन को भेज दी प्रॉपर
My lord, this matter relates to appointment on compassionate ground. My father died on 5/10/2015. And thereafter, I applied on 10/11/2015. My case was placed before the DLC on 17/11/2015, and accordingly, my case was recommended for the post of grade 3. But the SLC held on 11/8/2017. My case was not considered on the ground that lack of vacancy. I did not receive any communication from the authorities, and ultimately on 28/9/2021, I was furnished a copy of the mileage. Now I come to know that the authorities have not properly considered my case, showing the vacancy of only 2015, though that authorities are required to consider the vacancy of subsequent years. And as well as if I am not eligible for the post of grade 3, then my case should be considered again grade 4 postman. This is my humble submission.
Yes, what do you say, Mr. Dhar?
My lord, only this first thing is that, my lord, 2017 was rejected. It was in 2017 it was rejected. Now we are in 2023.
Explain.
His explanation is that, my lord, he has come to know in 2022. Otherwise, my lord, compassion appointment, my lord, with the lapse of time, my lord, whether that compassion, why this compassion appointment is in the very first instance is designed to give immediate relief to the families, my lord, so that they can, that hardship they can come over.
Then why do you take so long? Once the application is submitted, why do you?
No,
take
no, no,
so
we
long?
will not take, immediately it was in 2017 it was rejected. 2015, my lord, within 2 years time we have rejected it, my lord.
That's correct, but he is entitled to information about that. Have you communicated to him?
In 2021.
He may or may not accept your decision. Your decision may be right, may be wrong. He has a right to challenge it.
Yes.
How will he challenge it if you don't inform him? See, Mr. Dhar, it is one thing to say that somebody has approached with an application after 2 years, 3 years, 5 years. But if the
Madam.
person has approached on time and you delay it and you don't inform it, can you take the plea of delay? That will create a completely unacceptable situation.
My
You
lord-
can choose manner.
No, my lord,
Somebody will get it, somebody will not get it.
I accept, my lord. The thing is that I will take the instruction whether it was communicated earlier to him.
Also say that.
That part, my lord.
Say that.
Otherwise, my lord,
Ask for time to obtain instruction.
otherwise, my lord, that since grade 3 there was no post, if you go by clause 15 of the act, this office memorandum, yes, he is entitled to be considered for the next grade 4. That is there. That my lord, I accept.
Hmm.
Grade 3, but that not for subsequent year. It has to be for that year only, my lord, but for grade 4, the next level. That has to be considered. That is there,
On page
So you
29.
file your affidavit.
my lord.
On page 29, again, the concerned authorities has submitted the proposal.
Let him file his
Yes.
affidavit. Heard Mr. N. Sharma, Learned Counsel appearing for the petitioner, aggrieved by non-consideration oblique rejection of his application for appointment on compassionate ground by the SLC. The instant writ petition has been filed, inter alia contending that the ground on which the application has been rejected is untenable in the eye of law. Moreover, the petitioner was not intimated about the decision of the SLC taken on 11/8/2017 until a few days before filing of this writ petition. Mr. Sharma submits that even if it is accepted that no vacancy in the grade 3 category was available, it is not known as to why the petitioner's case could not be considered against the vacancies in grade 4 under the standing OM dated, government OM
16,
dated
1615.
1/6/2015.
Plus 15. No, plus 15. Plus
Clause
15.
15 of government OM dated
One-
1/6/2015. Mr. Dhar, learned additional senior government advocate Assam prays for some time to obtain instruction in others. NOM 6 weeks.
My lord, here I will appear as a standing counsel for 1, 2, and 3. My friend will, other there will conflict, my lord.
Okay, learned standing council, Sericulture Department Assam prays for some time to obtain instruction in matter. NOM 6 weeks, since Mr. Dhar had appeared and accepted notice for respond number
1, 2, and 3.
And Mr. D. Bora, government advocate Assam for respond number 4,
4 and 5.
respond numbers 4 and 5. Service of notice is deemed to be complete in this case. Extra copy of the writ petition, requisite in numbers, be furnished to the learned departmental council so as to enable them to obtain inspection and file them.
Date may be fixed.
At 6 weeks.
May I please lordship?
Yes.
This matter, my lord, pertaining to recruitment process of Central Armed Police Force for the year 2022. And lordship, my lord, petitioner had participated in the recruitment process for the post of Constable GD, my lord. And second round examination held on lordship 9/5/2023.
So
And
there are similar matters. Who is the CGC here? Similar cases have been disposed of by this court.
and petitioner declared disqualification on the basis of, my lord, wrong measurement.
You give him,
Fine.
give her a copy. We'll take it up at 12.
Yeah.
Give her a copy, yes, at 12.
At 2.
At 12.
Right.
At 12 PM.
Obliged.
Give her a copy, Miss David. There are similar orders passed by the court. Give her the copy.
Hello.
May I
Yes.
please, your lordship? This is also similar case, my lord. I applied for constable GD post. Pro recruitment of Central Armed Forces.
Have you got a similar order?
Yes.
Where is it, page?
Lordship, he has approached after 1 year, Lordship, and there is appellate provision he has not available.
So we'll ask him to go for appeal.
Lordship.
Which page is the order?
The process was concluded in May 2022.
Which page is the order?
Order, I don't have the next, my lord, I collected.
Rejection order is at page
So
40.
just file appeal and no one post reserve and all, this will not pass now.
No, yes.
That
Lordship.
stage is gone.
After 1 year, he has approached.
What is your name?
Tejamu. Lordship.
Equipment, 2020, 2 months. Disposed of.
Obliged.
Finding letter for motion item 5.
Second call, man. Second call. None appears for the writ petitioner even on the second call made during the course of the day. I find from the record that the petitioner's counsel was absent even on the previous date, that is 12/4/2023, when the matter was called up before this court. After going through the however, after going through the averments made in the writ petition, this court is of the opinion that merely because of absence of learned counsel for the petitioner, no adverse order should be passed in this matter. As such, registry is directed to engage an amicus curiae from the panel prepared by the Guwahati High Court Legal Service Committee so as to represent the petitioner and list the matter thereafter by reflecting the name of the amicus curiae in the cause list. Copies of the papers be furnished to the amicus curiae at least a week in advance before the matter is listed.
Order stayed against item 17.
Wait, please, your lordship. My lord, this IA is filed for vacating the stay order passed by this honorable court. It's matter relating to my lord sexual harassment at workplace. This is I am for the response number 7, the lady victim, my lord. This honorable court has passed one stay order at page 42. And my lord, this departmental proceeding against the writ petitioner was stayed by this honorable court. At page 42, lordship, and subsequent extension of the said order.
So who's for the, what is the matter, Mr. Dubey? There was some complaint made,
Yes, my lord. At page,
harassment, sexual harassment in
Yes, yes.
workplace.
Lord, we had
What
a
has happened to that?
internal complaint committee was there, my lord.
Hmm.
But subsequently, my lord, the matter was settled and the proceedings were closed.
Hmm.
And my lord, subsequently, my lord, a letter was issued by the private respondent, my lord,
Hmm.
saying that some of the observations that had been made by the committee, she's agreed by that.
Hmm.
But thereafter, my lord, the matter was pursued at our end
Hmm.
and my lord, the impugned disciplinary proceedings was initiated against the petitioner.
Hmm.
And being aggrieved, he has filed this case.
No, but disciplinary proceeding on what charge?
But the charges was basically blood that the closer
Hmm.
was not in terms blood.
Where is the, where is the memo by which disciplinary proceeding has been initiated?
My lord,
Which page is it?
my lord will take up the writ petition, my lord, at
Hmm.
page 23, my lord. Initiation page 22 actually.
Page 23. Hmm.
I will see the article of charges at page 23.
So this is the same charge which was before the internal committee.
My lord.
The internal committee's report is at page
49, my lord.
49.
39, my lord, inquiry report.
Hmm.
My lord, we find the observation at page 42. And conclusion at 43. My lord
So
will see
anyway,
page
now
45.
the point is,
Page
your
45. my
internal
lord, will see.
committee found that the charges were not
My
substantiated.
lord.
Therefore, you went ahead to, on a ground that the charges have been substantiated.
My
What
lord, at
kind
page
of a-
45, your lordship would kindly see.
Page 45.
Yes.
Yes.
This is the basically the letter that has triggered the subsequent actions, my lord.
So what is the impact of the internal committee finding that charge is not substantiated, allegation is not substantiated?
That's an issue, my lord, that is,
What is the law on that?
my lord,
You are aware or not aware?
but I am aware, but if your lordship permit me, but I've been given instructions and they have to file my affidavit in this case, my lord. But let me place those things on record, my lord, then your lordship may consider, my lord. Because it's fact, my lord, that it was initially closed, my lord, and was accepted also. But whether this reopening is permissible in law, my lord, that's question, my lord.
So we have to go to the root of the matter.
Yes,
It cannot be decided today.
Sure,
We'll have the matter after vacation. You complete your pleadings.
my lord.
Yes. Take down, I heard Mr. R. Goswami, learned counsel for the applicant. Also heard Mr. S. Banik, learned counsel appearing for the writ petitioner for the OP. So, writ petitioner. OP number 7 stroke writ petitioner. Mr. R. Dubey, learned standing counsel, Airport Authority of India is present on behalf of the OP numbers
1 to 6.
1 to 6. Full stop. This IA has been filed with a prayer to vacate the interim order dated interim order dated 24/2/2023 passed by this court in WPC number 949/2023. Full stop. Mr. Dubey submits that the issue raised in this petition cannot be resolved. No, Mr. Dubey submits that he be granted 3 weeks time to file affidavit, bringing the stand of the department on record. Full stop. After going through the meetings, I find that the issue raised in this writ petition pertains to a question of law which cannot be resolved in the absence of counter affidavit filed by the Airports Authority of India. Full stop. In view of the above, this matter is directed to be listed again on 8th of August 2023, along with the connected writ petition. Full stop. The respondents to file their counter affidavit on or before 1st of August 2023 by serving advance copy upon the opposite side. The interim order dated so.
It is already until further orders.
These matters will be taken up, the writ petition will be taken up. Right.
Can it be
A day
taken up?
earlier, a day later, my lord. Apart from it.
My lord, can it be taken for admission hearing along with
10th of August for admission hearing,
deeply?
along with the IA. Other part, writ petition listed on 10th of August for admission hearing along with the IA.
For admission, I can.
May plead your lordship. That's it, the matter relates to selection and appointment of in the post of grade 4, lordship. That's it, this is the second round of writ petition, lordship. As per the order of the first writ petition, lordship, the petitioner submitted representation before the authority, and authority has also passed an order stating that there is no vacancy. That's it. The petitioner has filed the present writ petition.
Where is the advertisement?
That's it.
Lordship, before
Advertise-
I need to seek some instructions because it is listed for the third time, your lordship. We have not yet received any instructions, even though we have written to the director. Some time may be granted, your lordship.
But this is a 2019 matter.
I understand, your lordship.
How much more time you need for
Just
instruction?
1 week time, your lordship. I'll get the instructions, your lordship.
That instruction is sought for, lordship, particularly regarding paragraph 13 and 14 of the writ petition. That is be sufficient, lordship, to.
What is there in paragraph 39?
That's regarding the number of vacancies, they have shown it as 84. But if we add the number of vacancies against various district lordship, it comes to 81 lordship. So there is no, let's see, then so there, as per the petitioner, there are 9 posts vacant lordship at the time of filing of the.
So what is the relief you want?
That's it, appointment as per the select list, lordship.
The select
Because
list is dated.
No, lordship, it is valid for 1 year, but it was mentioned in the select list that it will be used for future vacancies in the.
That is wrong. They cannot do it. If they do it, then the court will have to stop it.
Lordship.
So what relief is there any order extending the validity of the select
No,
list?
no, lordship.
We'll have it after 2 weeks, but
Lordship.
very difficult. Ms. So-and-so and counsel for the petitioner is present, Mr. D. Bora, Learned Government Advocate Assistant, ADV. For the petitioner, Mr. D. Bora, Learned Government Advocate Assistant. Appearing for the official respondents, prays for and is granted 2 weeks further time as last opportunity to obtain instruction. Respondent to the allegations made in the writ petition, more particularly the amendments made in paragraphs 13 and 14 of the writ petition. Let the matter be listed accordingly. Yes.
Highly obliged.
May it please, Your Lordship, my lord.
Yes.
My lord, 10 days may be required for filing affidavit in reply, my lord.
Affidavit.
Affidavit in reply, my lord. They have filed affidavit, my lord. Respondent filed.
Your name, please.
HP Gwala, my lord.
Mr. H.P. Gwala, Learned Counsel for the writ petitioner, prays for and is granted 2 weeks time to file rejoinder affidavit in response to the counter affidavit filed by
Respondent number 5, my lord.
respondent number 5. Mr. H. Sharma, Learned Additional Senior Government Advocate Assam, has appeared for respondent numbers 1 to 4.
Lordship.
And Mr.
1 to 3, Lordship.
1 to 3 and Mr.
M. Your Lordship, on behalf of respondent number 5,
N. Bhuya.
M for.
M. Bhuya, Learned Counsel for the respondent number 5 is present, are present. Who is for respondent number 4?
Or is a private respondent, Lordship, most probably somebody.
However, none is appeared for respondent number 4. Is service of notice complete on respondent number 4?
Complete.
List accordingly.
Obliged, my lord.
May please, Your Lordship. My lord, I want to file my reply to the affidavit filed by the official respondent. 2 weeks time may kindly be granted to me.
Affidavit in opposition filed by respondent number
2, 3 and 5.
2, 3 and 5. Mr. M. K. Sharma, Learned Counsel for the writ petitioner, prays for and is granted 3 weeks time to file rejoinder in response to the counter affidavit filed by respondent numbers 2, 3 and 5. The Learned Counsel for the respondent numbers 2, 3 and 5 is present. Mr. H. Sharma, Learned Additional Senior Government Advocate Assam, is present on behalf of the state.
right.
Please, Your Lord.
Lordship, may the matter may be passed over for the time being, Lordship.
Why?
Lordship, Mr. R.K.D. Chaudhary is on Lakes in court number 1. Lordship.
What is this matter about?
Lordship, I was discharged from service, Lordship, having on the basis of the report of the medical board, MIB, that I am suffering from S5, LES, Lordship.
That will require a detailed hearing.
Not detailed, Lordship. Only my prayer is to send the matter to the referral board, Lord, medical referral board.
Where is the order?
You can order, Lordship, at page.
Page?
Lordship. At page 32, Lordship. At page 34, paragraph 7, Lordship. Irrelevant. Earlier I was discharged, thereafter I was allowed to draw pension, Lord.
My appeal was also dismissed, Lordship, at 54.
What is wrong with this order?
Lordship, now if I take your Lordship to page 16, the discharge slip, Lordship, at page 16. Here, Lordship, on date of appearance was 28/9/2018, and date of discharge was 23/10/2018.
So what
In
is
this
the prayer, what is your prayer now?
Now, my prayer is, Lordship, since the medical board of the CRPF Composite Medical Board has declared that I'm improving. Thereafter, Lordship, on 34/2019 stable. Thereafter, Lordship, surprisingly, Lordship, on at page 21, they have declared me S5 with effect from 34/29, whereas on 34/29, I was declared a stable loss at page 20. So therefore, Lordship, my respectful prayer is only
You
for
want the matter to be sent to review board,
review board,
under which provision of the rules?
because there is a provision, Lordship. of
Which is the
review.
provision?
Review.
What is the rule? Mr. Dhar, you come prepared. We can't give so much time. Mr. R. Dhar, learned counsel for the petitioner, submits that this is a fit case for referring the matter to review medical board. The learned counsel, however, seeks some more time to examine the rules and address his arguments on that point. Ms. LDV learned CGC is present on behalf of the respondents. On the request of Mr. Dhar, this matter is directed to be listed again immediately on reopening of the summer vacation, so as to enable the learned counsel for the petitioner to address arguments in support of his prayer.
Item 28.
My lord, here in this case, some mistake in the name of the petitioner is there because I have mentioned the proprietorship concern, but it is in fact partnership, my lord. So I have to rectify, my lord. I have to file the application for amendment, my.
Mr. R. Hussain, learned counsel for the petitioner, submits that there is some defect in the petition insofar as the true identity of the petitioner is concerned.
Yes, my.
And therefore, he be permitted 3 weeks' time to file appropriate application seeking rectification of the error. Mr. A.K. Dattal and CGC is present on behalf of the respondent and does not have any objection if the prayer is allowed. In view of the above, let this matter be listed after the application seeking rectification of defect is filed by the petitioner.
Item 29, 30 and 31.
May I please? Let Kande pass over the matter for the time being. Mr. Finish Lex in court number 20.
What is this matter?
Lordship, he is praying for his promotion, Lordship. Departmental proceeding was also there, search sheet was also there. So it needs some time for a hearing, Lordship. Lordship may fix any other date, Lordship. Today may not be possible, Lordship. And pleadings are already complete, Lordship. Any other hearing date as per your Lordship?
Just for me.
Lordship.
There were a number of writ petitions.
Lordship.
Now, what has happened to the other ones? Other writ petitions? In the order dated 7/9/2022, I find there are 17 writ petitions. 21. Or 16 writ petitions. It is submitted at the bar that these writ petitions are ready as regards pleadings and therefore can be taken up for disposal at the stage of admission hearing. As such, on the request of learned counsel for both the sides and as agreed to by them, let these writ petitions be listed again on 20th of July 2023 in the column of disposal at the stage of admission hearing within courts. An attempt would be made to dispose of the writ petitions at the stage of admission hearing.
Item 32.
In this case, my lord, petitioner was working since 84. Government has appointed, regularized the service of all the work charge employees who were appointed prior to 93. So council has filed an affidavit showing that the petitioner was appointed in the year 1984. government has regularized the service in the year 2006. Then thereafter, for whatever reason, they have cancelled the service and it was not known to the petitioner. Now, finances filed an affidavit saying that he was appointed in the year 99. So for the purpose of finding out whether the petitioner was working since 1984 or not, the council has to produce the records. Because two contradictory affidavits are there. Finance says 99, the council says 84.
It appears not.
Council means
Dimas.
Sir. Yes, who is appearing?
They will have to produce the records regarding appointment and contradiction of petitioner survey. Yeah. it is there. I have shown, my lord, the order of appointment is there 1984.
Case in code 20, kindly after something.
No, this prayers don't make. We are not concerned. When a case is taken up, you have to make your stand.
They will have to produce the
Those
records.
prayers, where is the record?
Record is there.
Have you got the record?
Original record.
Records of appointment of petitioner will be necessary.
Mr. B.D. Das Lanet, Senior Counsel appearing for the writ petitioner, has invited the attention of this court to the contradictory stand of the Dimahasa Autonomous Council as well as the Finance Department, Government of Assam, as reflected in their respective affidavits to submit that as per the council, the petitioner was engaged initially in the year 1984.
8684.
Initially
Yes.
on 1984. But the Finance Department, Government of Assam has taken a stand that the engagement of the petitioner took place in the year 1999. First of, since the basic prayer of the petitioner is pertaining to claim of regularization in service in terms of a scheme floated by the Government of Assam, wherein all work charge casual employees appointed prior to 1993 have been regularized, with the exception of the writ petitioner herein and the 1993, but the petitioner has been left out. It would
No,
be
initially he was regularized. Subsequently, they realized that his appointment was in the year 1999. That was.
including the petitioner, but subsequently the regularization of petitioner service was cancelled. Hence, it would be necessary for this court to peruse the original records maintained by the Dimahasa Autonomous Council, based on which the affidavit has been filed. Full stop. The learned standing council, Dimahasa Autonomous Council, is therefore directed to produce the original records for perusal by this court. On the next date, let this matter be listed again as a fixed item on 19th of July 2023.
And they will produce the record relating to petitioner's appointment.
Absolutely, that's what.
Initially.
Just.
Mala, arrear salary for 20 months have not been paid. 20 months. Proposal is there.
In the meantime, the learned standing council of
Not
the
standing, government has to pay.
learned council for the respondents to also obtain specific instruction and place it before this court as to the reason why the salary of the petitioner has not been paid since last 20 months and the steps.
May I please, your lordship? Lordship, another similar matter is fixed on 21/6, lordship. The other matter was tagged along, but it was not listed today. This matter may kindly be taken up with the other matter, lordship.
Which is the other matter?
WPC 2969, lordship of 23. It is fixed on 21st, lordship.
I heard Mr. UK Nair Singh counsel appearing for the writ petitioner. Also heard Miss P. Sharma,
Lordship.
learned SC APSC, who submits that there is already an order of this court tagging up this writ petition along with WPC number
2969 of 23, lordship.
2969/2023, which is fixed on 21st of June 2023. And therefore, this matter be listed accordingly. First of Miss, your name, please.
I am appearing on behalf of MD Boran. Hello.
Transport Department.
For Transport Department.
Ilana Standing Council Transport Department is present and does not have any objection if the prayer is allowed. In view of the above, let this matter be listed along with WPC also.
Much.
Of next. 34 and 35.
Lordship, in
Lordship,
these two. In these two cases, Lordship, in one case, I have already filed my affidavit, Lordship. In the second case, Lordship, my affidavit is pending, Lordship. Sorry.
Any order passed in the first case probably will cover the second case. In the first case, the pleadings are complete, and on the last few occasions in which the matter has come up, Lordship will recollect, I have been trying to get the matter disposed of. In fact, I was trying to submit my arguments on disposal of the matter. Lordship, I have prepared a short synopsis also, and in fact, the developments post pendency of these during the pendency of these writ petition, the development which have come forward, Lordship, the finance department has taken some steps. It is more or less taken care of. Only with the wrong application of the PSB, and in what manner the PSB is to be applied, that is very much clear. That is only the only point which your Lordship will adjudicate upon. That is the only issue here.
Lordship, in the
Lordship,
second
kindly
case,
peruse
Lordship, a
this.
specific order was passed for filing an affidavit, Lordship. That is why I am praying, Lordship.
Lordship, my case is complete. And
1 minute.
yes, I'm sorry.
Let's have some pause.
I'm sorry.
Yes. Which is the second case?
Lordship, item number 35. WPC 41920.
419.
Second question, first case will cover to it. Let it be adjudicated.
Now, the issue here is, you say that the government has already accepted the prayer for grant of PSP.
Lordship, that is not the issue.
Then?
Grant of PSP is not the issue. The issue is how the petitioners who were appointed during the interregnum between the period when the rules were published prior to the publication of the rules and the date after the date when the rules were made effective. And for these set of employees, there is a specific provision in the manner in which the rules are to be applied. And for following of the procedure that has been prescribed in the proviso to Rule 5, the petitioners have been deprived of the actual pay fixation which they are entitled to under the ROP 2017. But after the filing of this present writ petition, the option that is provided for in the proviso to Rule 5, that has been allowed by the Finance PRU department. So in terms of when they have allowed the exercise of option that is entitled for these set of employees. So the in accordance with that exercise option, they have to allow us to
Right, understood. So if you succeed, then what is the relief your clients will get?
better pay. Yes.
Why this matter cannot be taken up in July? What is the earth-shattering urgency?
Lordship.
What is the earth-shattering urgency?
Lordship, only thing that
These are
for the last-
2023 matters.
Understand, Lordship.
Then why we'll fix it on July? If he wants to file affidavit, up to him. We'll give him a deadline to file it.
In the second case, in my case, pleadings are complete.
That's right.
I'll file, Lordship. Within 3 weeks, Lordship, I'll file, Lordship.
We'll fix a date and finish it off in one go. In these matters, what is the point in passing an order by force when the council wants to file affidavit? Then they will keep it pending, come for
Yes,
review.
this petition, the second petition, they file later on and was tagged with our petition.
That's correct.
Yes.
But,
Lordship, as best for convenience of the honorable court.
Take down heard Ms. D. Borgohain and counsel for the writ petitioner in WPC number, it is item 34, who submits that pleadings are complete in this case and therefore the writ petition be taken up for disposal. First up, Mr. A. Chamua is present on behalf of learned counsel for the petitioners in item 35. and submit that the state is yet to file affidavit in his case. First up, Mr. P. Nayak, learned Standing Council Finance Department, Assam submits that within 3 weeks from today, affidavit on behalf of the department will positively be filed in item 35. First up. Since both the matters are tagged up by an order of this court, the prayer made by Mr. Nayak is hereby granted. Register to list both these cases for in the column of disposal at the stage of admission hearing as fixed items on 27th of July 2023. Affidavit, if any, on behalf of the Finance Department be filed in item 35 on or before 20th of July 2023 by serving advance copy upon the petitioner's counsel, having regard to the no, that's all. We'll take it up for disposal on that day. No adjournment. You, Mr. H. Sharma, learned additional senior government advocate Assam, and Mr. So and so.
You Pathak appearing for Mr. H.K. Das.
Mr. H.K. Das, learned standing council GHC, is are present on behalf of the respective respondents. Yes, who is appearing in this case?
H. Pageborough appeared in the morning.
All right, what is the matter? Please tell us.
Lordship, they have challenged prayer that Lordship, they have challenged the speaking order. Earlier Lordship, one order was passed by this honorable court, Lordship, to pass a speaking order. A disciplinary proceeding was also pending at that time, Lordship. Now that disciplinary proceeding has already been concluded and the petitioner has also promoted, Lordship. That part is per my instruction is over, Lordship. And secondly, they have some prayer regarding badges, who to wear what badge, etc. are their claim, Lordship. They are challenging to memorandum, Lordship. This petition.
No, this is what was the relief prayed for? What is the relief prayed for? in
Relief,
this?
Lordship, is 21 of their writ petition, Lordship. ABC, 3 ABC, speaking order, BR order, and impugn departmental proceeding. Oh.
Yes, Mr.
Lordship,
Pageborough, what is
during
the
the
case?
pendency of this repetition, Lordship.
No, who are you, first of all? What pendency of the writ petition? What do you want?
Can it be taken up on the tomorrow, Lordship? I will file a written argument, Lordship. Lordship, today I have a difficulty, Lordship, that I have only the.
No, I've given you time. You mentioned in the morning.
Yes, Lordship. Can it be taken up the tomorrow, Lordship? I will do that, Lordship. I'm not running away from this court. Tomorrow, Lordship.
On the prayer of Mr. H. Pageborough and counsel to the petitioner, let this matter be listed tomorrow at the top of the list as a fixed item.
Much.
In the top of the list as a fixed item. That is B. Sharma, and CGC is present on behalf of the respondent.
May I please, my lord? My lord, the genesis of this case relates back to 2005, when an advertisement was issued by APSC, which my lord would find at page 19, my lord.
Yes.
My lord, this was for the post of lecturer in my lord, demonstrator in oral and dental pathology in my lord, the Guwahati the Regional Dental College, Guwahati, my lord. My lord can have page 19. The area of my lord challenge after the earlier proceedings is this, my lord. Just after the breakup of the reserve category community candidates, the paragraph next, my lord. The candidate who is in government service or in government-owned undertaking or other similar in organization, corporation, board, bodies, or in private employment must apply through proper channel and should ensure receipt of his application in the Commission's office within 15 days from the closing date of receipt of application, failing which it is liable to be rejected even it has been submitted to the controlling officer employer before the closing date. No advance copy of the application, my lord, will be accepted. Will be accepted. So, my lord, the procedure here is any government servant wants to apply against this application, he will have to submit his application to the controlling officer, and the controlling officer will forward it to the APSC, my lord.
Yes.
The respondent number 5 was selected, my lord. There was a select list published, and his name figured therein. I filed, my lord, WPC number 210606 initially, my lord, challenging that select list. And during pendency of that proceedings, my lord, he was appointed, and accordingly, my lord, another case being WPC number 5014-2006 was filed. Now,
appointed as what?
As, my lord, lecturer demonstrator in oral and dental pathology on 19/9/2006.
Acha, where is the post mentioned in the advertisement?
My lord would find it in the next page, page 20, serial number 4, my lord. Demonstrator of oral and dental pathology 1, including dental so-and-so, RDC Guwahati. Reserved for SC.
Reserved for?
SC. Scheduled caste. Both are, my lord. Then, my lord, those two writ petitions came to be considered, my lord, at page 25, order, my lord. 2011. If your lordship can have para 4, my lord, the grounds of challenge there.
Who has filed this writ petition?
This was by me, madam.
All right.
The challenge made to the selection and appointment of the respondent number 5 is on 2 grounds, namely, the academic career of the petitioner being by far better than the respondent number 5. He could not have been recommended, placing him above the petitioner, and the respondent number 5 having not offered his candidature for the post through proper channel as was required in terms of the advertisement, the APSC ought to have rejected his candidature instead of entertaining the same and eventually recommending him ahead of the petitioner. So, my lord, the first ground of challenge is no longer existing. It's only the second ground that is there.
Why first ground is no
First, my
longer-
lord, the honorable court said that in another different proceeding, the select list was put to challenge, and that proceeding was negated, my lord, rejected. So the select list as such is valid, my lord. But whether the petitioner's case could have been considered or not, that was what was considered in the earlier round of litigation. The honorable court came to a conclusion after hearing APSC and the department that the manner in which he had submitted his application was not in connoissance with the advertisement requirements.
So what is the order in this?
Lordship, if my lord can have the detailed procedure was done, then my lord can have page 30, my lord, para 10, that first ground was rejected. It is on record that the aforesaid select list was put to challenge in some other proceeding, and this court has upheld the such selection. That being the position, the court cannot take a different view of the matter. Thus, it will have to be held that so far as the selection of candidates so and so same has achieved finality and cannot be looked into afresh only to consider as to whether the petitioner should have been provided with a higher rank. than that of the respondent number 5. Now the issue comes, my lord. This now leads us to the second question as to whether the APSC
You're reading
could-
from which page?
page 13. Please. My lord, para 10. It is on record that the aforesaid select list was put to challenge in some other proceeding and this court has upheld the said selection. That being the position, this court cannot take a different view of the matter. Thus, it will have to be held that so far as the selection of candidates by the APSC is concerned, same has achieved finality and cannot be looked into afresh, only to consider as to whether the petitioner should have been provided with a higher rank than that of the respondent number 5. This now leads us to the second question as to whether the APSC could have considered the candidature offered by the respondent number 5. As noted above, the application submitted by the respondent number 5 was accompanied by an NOC dated 28/10/2005 issued by the joint director of so-and-so, under whom the petitioner was serving as dental surgeon. The NOC reads as follows. Page 31. This is to certify that Dr. Debeshwar Das was joined on 22/11/2000 as dental surgeon. He is working under this establishment till today. I have no objection if he apply for another post under Health and Family Welfare Department. Now, my lord, on perusal of the aforesaid NOC, what is seen is that the same is of a general nature and there is no indication that the respondent number 5 was allowed to apply for the post of demonstrator in terms of employment notice dated number 8 of 2005, dated 16/10/2005. In the advertisement itself, it was specified. I've taken my lord through that. I'll just skip that. On perusal of the aforesaid clause in the advertisement, what is seen is that the respondent number 5, being a government employee, was required to submit the application through proper channel, which according to the Health and Family Welfare Department is the Commissioner and Secretary to the Government of Assam in the Health and Family Welfare Department. As per the affidavit filed by the said department, the respondent number 5 was required to submit his duly filled in application form along with the documents to the Joint Director of Health Services, Golaghat, under whom he has been serving, who in turn was required to forward the same to the Commissioner and Secretary to the Government of Assam in the Health and Family Welfare Department for onward transmission to the APSC. The stand taken by APSC in their affidavit is very strange. The affidavit filed by the in-charge secretary APSC is that the application submitted by a departmental candidate along with an NOC is similar in nature to that of the application submitted by the commission through proper channel, and the same serves the purpose. According to the APSC, the application submitted in either of the two ways can be accepted. In the subsequent affidavit filed by one of the members of the APSC, the stand is more or less similar. Thus, according to the APSC, although the respondent number 5 did not submit the application through proper channel, as is understood in common parlance by the APSC, within its competence and jurisdiction, acted upon the application on the basis of the above noted NOC dated so and so. If the above aforesaid stand of the APSC is accepted, then in that case, all the government employees are entitled to apply for another post, either in the state government or in the central government, or any other organization without his or application being submitted through proper channel if a general NOC accompanies such application. The nature of the NOC dated so and so has been noted above. In the said NOC, there is no whisper that the respondent number 5 was allowed to apply for the post of demonstrator in response to the aforesaid advertisement employment notice. The said NOC is of a general nature without specifying anything. The APSC, being a constitutional body, ought to have acted more carefully in such a matter, and now, after accepting the candidature offered by the respondent number 5, has come to his rescue by filing the aforesaid affidavits, taking the stand that even a general NOC serves the purpose of submitting the application through proper channel. If this stand of the APSC is to be accepted, no candidate in government employment or in any other organization is required to submit his or her application to the APSC for any post through proper channel. Mr. Cienso, for the respondent number 5, has drawn my attention to the affidavit filed by the respondent number 5 on 1/12/2010, in which in paragraph 6, a stand has been taken that the respondent number 5, while serving as a dental surgeon under the Joint Director of Health Services, had submitted an application before the Secretary to the Health and Family Welfare Department through proper channel with a prayer to allow him to appear in APSC examination, and that the said application was duly forwarded on 28/1/2005. If the application was submitted through proper channel, it is not understood as to why the same was required to be accompanied by the aforesaid general nature of NOC. However, particular enclosure to the said affidavit depicts another picture. Annexure A to the said affidavit dated 28/10/2005 is his application purportedly addressed to the Secretary to the Health and Family Welfare Department. For a ready reference, the said application is reproduced here in below. Now, my lord, that application is there. With due respect, I beg to state, I want to appear in an examination for the post of demonstrator, RDC, which will be conducted by NOC. Therefore, I request you to kindly grant this favor and do the needful. Forwarded to the secretary so-and-so for favor and kind consideration. Apart from the fact that the said application was not addressed to the APSC, it also does not specify as to the post for which the application was made. Further, the said application does not specify as to whether the same was accompanied by a duly filled in application form addressed to APSC along with the testimonials for the post in question, that is demonstrator. The said letter was addressed to the secretary so-and-so without any specific prayer therein, and there is nothing to show that the said application was accompanied by the requisite application form. There is also nothing to indicate that the respondent number 5 had pursued the matter any further. Be that as it may, the above aspect of the matter need not detain us, as the original application form along with the enclosed testimonial forms part of the record which have been produced by the Learned Standing Council Health Department. The application as has been produced by the Learned Standing Council does not indicate forwarding of the same through proper channel, or for that matter by the joint director of so-and-so under whom the respondent number 5 had been serving, or by the secretary so-and-so. The only document on which the APSC and the respondent number 5 have harped upon is that the general NOC, which purportedly accompanied the application form, unfortunately, the APSC has tried to justify its stand in accepting the candidature of so-and-so on the basis of the said NOC by making a statement in the affidavit, which has been mentioned above. In the affidavit filed by the respondent number 5, he has enclosed the purported personal copy of the application through which his candidature was offered. The said personal copy has been annexed as Annex X. On perusal of the said application, along with the application form which the respondent number 5 had submitted to APSC, I find wide variation. However, no opinion is expressed in this regard, as it is the contention of the respondent number 5 that the copy enclosed to the said affidavit dated so-and-so is his personal copy. However, what is required to be mentioned is that even in the said application, there is no indication of submitting of the same through proper channel. If the respondent number 5 could keep his personal copy, he could also keep, or would have kept, the forwarding letter of the controlling authority addressed to so-and-so if at all the same was submitted as such. However, this matter did not detain us, as it is an admitted position that the respondent number 5 did not apply through proper channel as is understood in common parlance. It is in the aforesaid background, the authorities in the health department had reverted back the respondent number 5 to his earlier service. However, there was an interim protection provided by this court about which mention has been made above. In other words, the appointment of the respondent number 5 in the present post or demonstrate subject to outcome of the present proceedings. Mr. So-and-so Learned Counsel for the petitioner submits that if the candidature of the respondent number 5 is not accepted, then the petitioner being second in the merit list is required to be appointed against the post in question. On the other hand, so-and-so Learned Counsel submits that having regard to the service already rendered by the respondent number 5 in the present post, his appointment should not be allowed to disturb on technical ground of non-furnishing or application through proper channel. Taking note of all the relevant facts as well as the aforesaid submissions made by the Learned Counsel for the parties, both the writ petitions are disposed of by directing the Commission Government of Assam in the Health and Family Welfare Department to take a decision in the matter consistently with the observations made above. Needless to say, while arriving at the decision, he will be guided by relevant factors required to be considered in such a matter. Let the decision be taken by a speaking order as expeditiously as possible, but not later than 31/3/2011. So, my lord, after
So what is the decision really? The decision was to?
My lord, the honorable court, this honorable court laid down as to what it should be, and then directed the, my lord, the commission secretary to take a call basing on that.
Call on what?
On the whether the application form was submitted in the manner required.
But his appointment, has it been set aside?
Well, that will be subject to that only, madam. If it is found that the application was not submitted in the proper channel or the manner it is required, his very selection goes.
No, Mr. Nair,
Lordship.
I'm asking one thing. The government cannot set aside his appointment because the appointment has been made by the department
Lordship.
on recommendation of the APSC. Correct.
Lordship.
Now, the learned single judge has made certain observations which are understandable. The learned single judge found that it was established that he did not apply through proper channel.
Lordship.
Therefore, whether he applied through proper channel or not, that is not a matter to be decided by the government. Because that finding has been recorded by the court.
Already recorded.
Recorded.
Mm.
But the learned single judge did not set aside his
No,
appointment.
no,
How can the government now set aside the
no,
appointment?
what the, my lord, the honorable court required was that you take a decision in the, not on the proper channel, take a decision on the whole issue, even with regard to, my lord, setting aside. That will be, have to be read into it, my lord. Otherwise, because otherwise it's no direction, my lord.
That we can't.
My lord will have it, my lord.
Whether it's a direction.
No,
or
no,
no
my lord
direction,
would have
we
it.
cannot comment.
My lord would have it. He,
Then what happened after this order?
then,
What
my
happened?
lord, they come to a decision. Now, one thing, my lord, before this whole episode began, the government on their own reverted him back on this ground itself. Which was without notice. This honorable court, my lord, interfered with that matter because
Where
it
is
was,
that order? Where is that?
but that order, my lord, I'm not having, but there is a mention here, my lord. I can show that. But it's recorded in the early order. Five orders.
Page 26. Page 26.
Lordship. My lord may have page 26,
36.
26, my lord.
Just a minute. This order at page 36 was passed in terms of the earlier order of 25th of January.
Lordship,
2000.
lordship. And the earlier proceedings, my lord, that was in WPC number 6457 of 2006, my lord. My lord will see how the government has understood this order.
The government is absolutely right in third paragraph. Proper channel, is it a ground to set aside his appointment?
My lord, when the, no, my lord, when the, no, my lord will read
These are
further.
all directory procedural matters.
My lord will read further to para 6, my lord, of that page 37, my lord. My lord, they are trying to create a case here, my lord. It was the advertisement specified that it should be through proper channel. The affidavit of the government is proper channel means through from the commission secretary. Because, my lord, the application need not reach the APSC in this connection on the last date fixed. There is a 15 days more time given. The 3 paragraphs, my lord, will have a look.
So you are challenging this order of 23rd September
Lordship.
2011.
Lordship. Why I am telling, my lord? I understand, my lord, the time here is gone too much. But I understand, my lord. But the issue here, my lord, would see when the honorable court has already come to a conclusion that the APSC was wrong. Could have the government, my lord, in paragraph 6 taken this plea, my lord?
No, the court has asked the government to take a view.
My lord will say consistently with the observations made herein above. That's the requirement, my lord. That cannot be obliterated. The requirement, the observations made above is deprecating that action, saying that that is not
So
proper.
that means then you have to, then that relief, the learned single judge should have granted the relief.
My lord, the learned single judge had remanded back the matter not to find out whether, my lord, the application was through proper channel or not.
See, Mr.
Understand, my lord,
this
understand.
court
There
will
is some
comment on
ambiguity.
the order of learned single judge.
There is an ambiguity there. I'll admit to that.
We will not say anything. The learned single judge has passed an order on the facts of the case.
Lordship.
That order has attained finality.
Lordship.
All we have to see whether this
Compliance order.
this order, 23rd of September, is irrational. Does it in any manner go beyond the scope and ambit of the order of the learned civil judge? If the answer is in the negative, we close the writ petition. And my view is we should dictate the order unless you have anything to say.
My lord, I've said what I've said. And if that's the view, my lord, I may be. Because then that last paragraph,
Mr. Nair,
understand, last
there are
paragraph,
two aspects here.
lordship,
As far as the select list is concerned,
It's
that
not-
validity has been affirmed.
offer,
So the selection process is correct.
correct.
Only issue is, was the application process correct? What you are saying is the APSC said you apply through proper channel. You have not done it. Now, the government, the commissioner has rightly said that these are all mechanisms to accept application. If the government doesn't have any objection to his application, and it does not say that it is a mandatory requirement, otherwise the application will be rejected. There is no such clause in the advertisement.
Yes. There is a,
What
clause.
is it?
There is one. That's what my case is, man. Your lordship may come to the judgment itself, my lord, where the
No, no, no,
advertisement.
where is the clause?
Clause,
Advertisement.
that clause is, my lord, here. I'm just
Yes.
placing it. My lord will come to page 28, my lord.
Page?
28. This is the thing, my lord, which they are trying to now overcome. My lord will have the APSC advertisement requirement so and so. The candidate who is in government service or in government-owned undertaking or other similar organization or in private employment must apply through proper channel and should
This is the
ensure.
part of the order of the court. I am asking you.
No, this is the clause, my lord, which it's slightly unreadable here. My lord can read it from here. Same thing has been quoted. That is at page 19, my lord. My lord can have page 19. That's the advertisement's requirement. It says candidate who is in government service or in government-owned undertaking or other similar organization, corporation, so and so, or in private employment must apply through proper channel and should ensure receipt of his application in the commission's office within 15 days from the closing date of receipt of application, failing which it is liable to be rejected. Even it has been submitted to the controlling officer employer before closing date. No advance copy of the application shall be treated as valid for determination of eligibility of a candidate. So his application, my lord, at best is an advance application. It could not be. Now, for the reason that they have done it and they have put him at serial number 1, the APSC took a stand contrary to the advertisement and their normal procedure. 3 affidavits were filed before this honorable court in that proceedings. Earlier to that order, my lord would find 3 affidavits were filed. The APSC member came and filed an affidavit. Then this honorable court came to a conclusion as to by accepting the thing from the health department, which said that it has to be always routed through the commission secretary. No other possible procedure is there.
All right, so this is an advertisement of 2005.
5.
Now, you want that he should be thrown out and your client should be appointed. Is that what you want, Mr. Nair?
That would be the ideal situation for me, my lord. But
Are you really asking for that?
I'll not be, my lord, if not by protecting him also, my lord, if I can be accommodated. Because, my lord, if lordship.
What
comes-
is your client doing now?
He is private practice. He's not even government job. He is interested. my lord.
And how old is he now?
He would be around. He would be around 30.
No, no.
45.
45.
45. Just on the brink.
Brink of what?
The last, if I can.
He's on the
explain to
brink
government-
of dismissal, I can
No,
understand.
that's one, a brink of appointment to government service. And then 3 years for me, 48, my lord. I'll get 3 years, SCR. 3 to 5 years I'll get. It's in that context, man. This, he has been, before this honorable court.
Private dental surgeons are doing well.
Good, my lord. He's, otherwise he has good hands, my lord. That much I know. He has good hands. And
Has he tried it on you?
no, my lord, I tried it on someone whom I know, my lord.
Anyways, that was on a lighter vein,
Light.
but yes, what do you have to say, Mr. Gogoi?
Here, my lord, already, my lord, it has been reflected in our speaking order that since, my lord, the APSC has accepted it and on merit, my lord, on the selection and merit, there is no, my lord, irregularity found by this honorable court, my lord, in the proceeding already held, my lord. Only this, my lord, irregularity regarding the submission of application. So on that point, my lord, government, my lord, finally said that, my lord, will be
And
accepting.
where is the order by which this select list, his reversion order was set aside?
But that is not part of the
That
record.
is not part of the records. My lord would find it in page para 5 of the
Well,
judgment.
one copy they have, my lord.
Asadi.
The reason for interference is, my lord, that because of the pendency, during the pendency of this to writ petition, since, my lord, the order of reversion was passed, so, my lord, honorable court interfered.
Interfered, and my lord, that's why it was said
Yes,
that it is subject to outcome of this proceeding.
yes.
My lord, it had para 21, page 34, madam. It has been reflected there, madam.
Page
That-
34.
Page 34, para 21. The last few lines, madam. Para
Yes.
21. In other words, the appointment of the respondent number 5 in his present post of demonstrator is subject to outcome of the present proceeding. Now, my lord reads that with para 23. So the decision would also include that.
No, no, this interim protection was provided in WPC number
65. 6457/2006.
but it finds mention in WPC number 2106 of 2006, which is earlier. 2106 is earlier.
Yes, madam.
2106
Then
is
how
early.
can 2106 order
So
mention?
this
about-
order came subsequently, madam. It came in 2011.
11, finally.
No, no, the-
That writ petition,
what is
earlier
the
writ petition was.
Situation here, he was selected in serial number one,
One.
the respondent number 5, and petitioner was in serial
Two.
number 2, correct?
Lordship.
So this select list was under challenge. It was under challenge in this proceeding,
Lordship.
2106 of
Lordship.
2006, on twin grounds.
Twin grounds.
First, that the respondent number 5, the petitioner claimed to have better merit
Lordship.
than the respondent number 5.
Lordship.
And secondly, that his application was not submitted through proper channel
Lordship.
as per requirement of the advertisement.
Lordship.
Now, the learned single judge has found that there is no irregularity in this select list.
Why? Because there was an earlier proceeding
Hmm.
wherein the select list was put to challenge, and that this honorable court
Which para is the
rejected.
finding?
Lordship, that's there, madam.
Para?
I'll just place that, madam. Para 10, madam. Para 10, page 30, madam. So that issue was not gone into. It was on record that the aforesaid select list was put to challenge in some other proceeding, and this court has upheld the said selection. That being the position, this court cannot take a different view of the matter. Thus, it will be held that so far as the selection of candidates by the APLC is concerned, same has achieved finality and cannot be looked into.
So where is this order? Where is the order?
This order, my lord, I don't have with me. madam.
No, but does it not mean once a select list has been found to be in order,
Lordship.
how can it be tinkered on X
No, ma'am.
ground or Y ground?
No, my lord, the select list is okay. But when you find that the person could not have been considered,
Then the select list is not okay.
it would be, my lord, then that person's candidature will have to be interfered with.
That would mean the select list is not okay.
Will be in a way, my lord, but it's not on merits, it's on technicality then, madam.
That is not clarified here.
That order of this honorable, I can't say more than
That's,
that.
you're right. But the problem is, on one hand, the court says the select list is in order,
Order.
meaning thereby that there is no need to interfere.
My lord, there are three factors here. One, his reversion was interfered by my lord, saying that it will be subject to outcome of this case or the orders that would be passed. Two, in some proceeding, the select list was put to challenge and it was rejected for X, Y, Z, whatever ground, my lord. So it would act as a res judicata. Should. Then this honorable court says that this select list having been not interfered, will not go into that. But it goes into the aspect as to whether the person could have been a candidate before the APSC. Now, this order has attained its finality. Madam. Nobody has put that to challenge.
Which order?
The order which is there before my lord now. The
25
last
one.
order,
25 one. Yes.
This nobody has put it to challenge. Madam. So this order, both parties have accepted. So the question as to whether his appointment, his consideration by APSC is proper or not, is open, my lord.
That is precisely what the court has to decide.
Lordship. No,
How
it
can
has.
the government decide that?
No, it has. It has decided and said, you take a call. I don't know why, for what grounds it has said so. But in other words, my lord will come to para 34, para 20, page 34, para 2. In other
No,
words, the
so you are saying the meaning of you take a call means you dismiss it.
my lord,
you throw him out.
no, subject to what my lord will fall from my lordship. My understanding of para 24 is, para 24 is qualified with the words consistently with the observations made above. And all the observations made above
Are
says
against the,
against it.
but the court has not set aside.
It has not set aside. Maybe it felt a bit that it should be that onerous duty should be done by the government. So it was remitted to the government, my lord. This is my humble submission. What is there, my lord? It's there. But one thing, my lord, the issue that the finding that the government has recorded in para 6 is clearly inconsistent with the.
Yes, but then that's the point.
My lord, understand the anxiety of my lord. My lord is a equity court. Understand that, my lord. But when they are dealing with the order of the court, they should be a bit more prompt, my lord. They should be applying their minds properly. Now, this gives rise to an impression to the public that whatever you are doing is to protect the respondent number 5, right from the beginning. Why? APSC comes.
Oh, Mr. Nair, the government has appointed him. The government will protect him.
No, my lord. Even before that, the stand that was taken by the APSC before this honorable court was contrary to the position. That was deprecated, my lord. That led to this.
That's fine. APSC part was over.
Oh.
We would have understood if his appointment was set aside. Then the matter would
It
be
would,
very
it should, by the findings that are there, that would have been the logical conclusion, but it was not done.
was not
It
done.
was not done.
So if it was not done, the
It was
government was asked to decide.
and they have
They
decided.
have decided. Their logic, if it is not found to be irrational, if you think they have committed contempt of court, then the remedy is somewhere else.
Maybe, my lord, no.
But how can this court say that no, your decision must be in one direction, that is to throw him out?
Because only.
That how can this court?
No, no, I'm not on that. I'm not on that. I'm only on the question that if the decision, whatever the decision would be, my lord, that would be some, whether he's gone, he's kept different. But the manner in which the application is to be given, they could not have taken a view contrary to what this honorable court has said, or they should have given reasons for that. The
They have
APSC.
given the reasons.
No, my lord, that is para 6, my lord.
Oh, para 5, see the reason.
Lordship,
The
basic objective of submission through proper channel, so and so it's hardly open to say non-submission through proper channel as usual has frustrated the underlying object. This has been deprecated by the honorable single judge. Now, my lord will come to 6. That is the main thing. Next page, my lord. In the present case, APSC in its advertisement stipulated for submission of application. However, APSC itself accepted the candidature.
That is the reason given by them.
Then, which, my lord, in the honorable court.
Mr.
has-
Nair, we are coming round and round.
No, same issue, my lord. Need not go into it, my lord. My lord will take a call.
If the court was of the view that the APSC
It
has
should have
committed
interfered
a
with it.
mistake or an error by accepting it, then the logical.
My lord, what
conclusion-
wait before the honorable court at that point of time, because I was not the
That's right,
consider.
that's
My lord, I can't. But what has fallen from your lordship is the exact position.
What
That
is the
should have
point
been,
in doing it round and round? Either
there is no point.
set aside or.
No. My lord will take a call, my lord. Take a.
Because see the 2005 advertisement. What are you going to do today? Upset the whole thing? The court of equity will not. get
I
it.
understand. My lord, it have to be a court of
This
equity.
is obviously the learned single judge has passed an order taking note of the facts and circumstances. Yes, you are right. The tilt was
towards me.
definitely towards your client.
Lordship.
But the fact remains that that final relief was not
Was not
granted to you. The matter was remanded. Then the government has to be understood to have the right to take a decision. on its-
Independent,
Yes,
but not inconsistent.
of course, in the light of and not inconsistent. But where is the finding that the APSC could not have accepted? Where is that finding?
By the honorable single judgment.
Yes.
The honorable single judge's finding to that effect
Hmm.
is there in a different way, madam.
Hmm. Para 15. Take the judgment.
My lord, would para 20,
Yes.
the last 3 lines, my lord. However, this aspect of the matter need not detain us, as it is an admitted position that the respond number 5 did not apply through proper channel, as is understood in common parlance.
Correct. So the finding is he did not apply through proper channel.
Lordship,
But whether that would vitiate his application, that is a matter the learned single judge. did
has
not-
left it, my lord, open.
Yes.
My God, ma'am.
Therefore, viewed from one angle, it cannot be said to be.
No,
only-
my lord will have to take a
The
balance.
department did not record a finding that he did apply through proper channel.
No, they say, my lord, that the object is satisfied,
Correct. So that
which,
is
my
what-
lord, which is contrary to their stand in that writ proceeding.
that is another matter. But is it contrary to any observation of the learned single judge?
Generally, maybe, my lord, but specifically, it would be difficult one.
Acha, this reversion part, I am still not clear. Can you?
What
please
had
tell me
happened
what
was,
is-
my lord, once it was brought to the notice of the government that he had not applied through proper channel, they immediately reverted him back to his earlier service. He approached
Earlier
this,
service was?
as a dental surgeon in the health department, my lord.
Hmm.
Then, my lord, this honorable court,
Hmm.
then naturally it was without notice and everything was under challenge. This honorable court grants him an interim protection.
In which writ petition?
That is, my lord, 6 para 5, my lord.
That is in 6.
6457/2006, which was disposed of on 17/9/2007
Hmm.
by quashing that order, my lord. 30/11/2006 order. There was an interim order. That interim order got finally. Asani order could be another. 64572.
Subject to outcome of this writ petition.
Lordship. And then, my lord, here para 21, that is noted that it will be subject to outcome of this proceedings.
All right, who is appearing for the private respondent?
I'm appearing.
You can only spoil your case. That is the only option you have. How much time will you need to spoil? your case?
not take it. I'll leave it alone.
Anybody else wants to spoil his or her case? Sometimes the respondents council help us to allow the writ petition.
Happened many times.
Hmm? Yes. It done heard Mr. UK Nayan and its senior counsel assisted by Eldas, my counsel appearing for the writ petitioner. I've also heard Mr. B. Gogoi, learned Standing Council Health and Family Welfare Department. Some appearing for the respondent numbers
1 and 4.
1 to 4,
1 and 4.
1 and 2.
1 and 4.
So 1 and
2 and 3 is the APSC.
1 and 4. Ms. P. Sharma, learned counsel is appeared for respondent numbers 2 and 3. Mr. S.K. Talukji, learned counsel is appeared for the respondent number 5. First up. This writ petition has a checkered history. And therefore, the facts leading to the filing of this writ petition be briefly noticed here and first up. The writ petitioner and the respondent are both dentists by profession. First up. on 14/10/2005, the Assam Public Service Commission, bracket APSC, that is the response number 2 herein, had published an advertisement notice inviting applications inter alia for filling up one post of demonstrator of oral and dental pathology in the Regional Dental Center, bracket RDC Guwahati. Full stop. The said post was reserved for SC category candidates. Full stop. As per the advertisement notice, the candidates were advised to submit as per the advertisement, those candidates who were in government service or in government owned undertakings or in service of other similar organizations, stroke corporations, stroke boards, stroke bodies, or in private employments were asked to apply through proper channel within 15 days from the closing date of the application. Full stop. Full stop. The read petitioner, the response number 5 herein was serving as response number 5 was serving as what?
My lord, he was serving as a dental surgeon.
Dental surgeon.
Dental surgeon
Under
under the Joint Director of Health Services, Gulaghar.
at that point of time, the response number 5 was serving as a dental surgeon under the Joint Director of Health Services
Gulaghar.
at Golaghat.
Lodge.
What about the petitioner? He was also working.
No, he was private.
However, the petitioner was in private practice as a dental surgeon. Full stop.
My lord, I have filed a affidavit in opposition. Lordship will kindly, my lord, make an observation to that. Para 9, my lord, is relevant.
The response number 5 had applied for the post along with an NOC from the NOC means no objection certificate from the
My lord, he was under 3F that time. my lord. Sorry, my lord, the petitioner was under 3F and he had applied through proper channel. 3F. my lord. 3F.
then you write. The
Demonstrator,
petitioner was serving as a
demonstrator in the Regional Dental College itself.
in the RDC. His appointment having been made under regulation 3F of the APSC limitations. And what is that rule called? APSC?
My lord, it's called the Assam Public Service Commission, bracketed
of
limitation of functions,
Regulation.
regulation 1951.
Full stop. The petitioner had submitted his application through proper channel.
Lodge.
However, insofar as the response number 5 was concerned, he submitted his application directly, but by enclosing a no objection certificate, bracket NOC from the
Joint Director of
Joint
Health
Director-
Services, Gulaghar.
Health Services, Golaghat. Full stop. On conclusion of this selection process, the APSC had published select list dated
My lord, the select list is dated
3/3/2006.
3/3/2006.
3/3/2006. Full stop. In the said select list, the name of the response number 5 appeared at serial number 1, whereas the petitioner's name appeared at serial number 2. Full stop. The aforesaid select list was called in question by filing a writ petition
Okay.
alleging, inter alia alleging that the response number, the petitioner being better in terms of merit, he ought to have been selected in the top of the list. Full stop. However, the challenge made to the select list was turned down by the learned single judge in WPC number. Is it Facts are so inadequate.
There is no
Is
writ
it
petition
WPC
number.
Huh?
The writ petition number, the earlier select list
What
number.
is 5014 of 2006?
That is my second writ petition after he was appointed, madam. Those two writ petitions were taken up together. 2106, 2006.
Was declined in a proceeding. The case number whereof is however not available on record. Full stop. Be that as it may, it is the admitted position of fact that the challenge made to the validity of the select list was rejected by this court, which fact finds due mention in the order dated 25/1/2011
Lordship.
passed by the learned single judge, which fact also finds due mention in the order dated
25/1.
25/1/2011 passed by the learned single judge in WPC number 2106/2006 referred by the writ petitioner.
Madam, one more number, 2106, 2006, along with 5014, 2006.
As well as 5014/2006 passed by the learned single judge. Filed by the writ petitioner. Full stop. Full stop. The writ petitioner has also filed WPC number 2106/2006. Inter alia contending that the respondent number 5 not having submitted his application through proper channel, which according to the writ petitioner is the Commissioner and Secretary to the Government of Assam, Health and Family Welfare Department, his application ought to have been rejected by the APSC. First up. Therefore, the selection and appointment of the respondent number 5 in the post of so-and-so,
Demonstrator.
in the post of demonstrator of
Or-
oral and dental pathology in the RDC was illegal. Full stop. What is the other writ petition about?
My lord, when he was appointed on 19/9/2006, the other writ petition, my lord, 54106 was filed.
Selection. not
Selection,
appointment.
selection is, my lord, 2106, appointment is 501. He was appointed on 19th, my lord,
During the pendency of WPC number
2106.
2106/2006, order of appointment was issued in favor of the respondent number 5 on
19/9/2006,
19/9/2006.
which led to filing of WPC
which
number
led to filing of WPC number
5014.
5014/2006.
And both were heard and disposed, my lord, with that 25/1.
The both the aforesaid writ petitions were disposed of by the learned single judge by the judgment and order dated 25/1/2011 by remanding the matter to the government for a fresh decision in the light of observations made in the said order. Full stop. It would be pertinent to mention herein that, as is evident from the materials on record, during the after the institution of WPC number this
2106.
2106 of 2006, the government had apparently issued order dated 30/11/2006, reverting the petitioner back to his original post under the Joint Director Health Services Golaghat, full stop. Assailing the order dated 30/11/2006, the respondent number 5 had approached this court by filing WPC number 6457 of 2006. Full stop. The aforesaid writ petition was disposed of by the learned single judge by order dated 17/9/2007.
Lordship.
Inter alia providing that by setting aside the order dated 30/11/2006, inter alia providing that the fate of the petitioner will await the outcome of WPC numbers 2106/2006 and WPC number 5014 of 2006, which were pending disposal before this court. Full stop. Eventually, both those writ petitions having been disposed of by the judgment and order dated 25/1/2011, the government took a fresh look at the matter and thereafter issued the impugned order dated 23/9/2011. Full stop. The operative part of the impugned order dated 23/9/2011 is found to be relevant and therefore is reproduced herein below for ready reference. Full stop. In page 36, double tick to double tick. Stop. By drawing the attention of this court to the observations made by the learned single judge in the judgment dated 25/1/2011, Mr. Nair submits that the learned single judge has made clear observations by holding that the respond number 5 did not apply through proper channel as per the requirement of the advertisement notice. Full stop. Further, the order was to pass to consider the matter. Further, by the order dated 25/01/2011, the commissioner of the department was asked to take a fresh decision in the matter, which was consistent with the observations made in the order. Full stop. Therefore, by coming to a conclusion that the APSC was justified in accepting the application submitted by the respondent number 5, submits Mr. Nair. The government has taken a view which is inconsistent with the observations made in the judgment and order dated 25/1/2011. On such count, the impugned order deserves to be set aside and the matter be directed to be considered afresh. Full stop. Mr. Gogoi, that is standing counsel for the Health and Family Welfare Department, on the other hand, submits that the departmental authorities have expressed opinion on the merit of the case without in any manner going against the observations made by the learned single judge. Full stop. However, since liberty was granted to take a fresh decision in the matter, the opinion has been expressed in the impugned order dated 23/9/2011 by taking note of the facts and circumstances of the case. Full stop. Next, by referring to the counter affidavit, statements made in the counter affidavit filed by the respondent number 5, Mr. Talukdar submits that what is the submission?
Well, in fact, in para 9, I have stated
Oh, what is the submission?
that there is an administrative instruction which says, my lord, that it will ultimately, my lord, it will rest on the authorities, my lord, considering the applications, whether the procedure is right or wrong.
Mr. Talukdar submits that as per standing administrative instruction as projected in para 9 of the counter affidavit, it is always upon the departmental authorities to consider and take a decision as to whether the procedure of submission of application is correct in a particular case. Full stop. In this case, since the administrative department did not find any fault with the procedure adopted in submission of application by the respondent number 5, there is no infirmity in the views expressed in the impugned order dated 23/9/2011. Full stop. I have considered the submissions made at the bar and have carefully gone through the materials available on record. As has been noted above, this court has already declined the challenge made to the select list dated so and so. Insofar as the merit of selection of the candidates is concerned, and the learned senior counsel for the petitioner has also submitted in his usual fairness that said aspect of the matter is no more res integra. Full stop. Since the only argument of Mr. Nair is that the impugned order dated 23/9/2011 is contrary and inconsistent with the views expressed by the learned single judge in the judgment and order dated 25/01/2011. This court has meticulously gone through the aforesaid order and finds that the learned single judge has categorically observed that the petitioner did not apply through proper channel. However, whether such a deficiency would automatically lead to disqualification of the petitioner on account of forfeiture of his candidature is a matter which has not been dealt with by the learned single judge in the judgment and order dated 25/1/2011. Full stop. In the impugned order dated 23/9/2011, the commissioner and secretary to the department has also recorded a finding that the respondent number 5 did not apply through proper channel strictly in compliance with the requirement of the advertisement notice dated 14/10/2005. However, the departmental commissioner was of the view that such deficiency would not be sufficient to reject the candidature of the respondent number 5. More so, since the APSC has accepted the same after taking due note of the NOC issued by the Joint Director of Health Services, Golaghat. Full stop. The aforesaid view taken by the departmental authorities appears to be a plausible view, and the same, in the opinion of this court, does not in any manner contradict the observations and findings recorded by the learned single judge in the judgment and order dated 25/1/2011. Full stop. Full stop. Since the learned single judge had granted the liberty to the departmental commissioner to take a fresh decision in the matter, it cannot be said that the views expressed by the commissioner in the impugned order dated 23/9/2011 was beyond his competence when viewed in the light of the judgment and order dated 25/01/2011. First stop. It is also to be noted herein that the advertisement in this case is of the year 2005, and the select list was published on 3/3/2006. Full stop. The respondent number 5 is also serving in the RDC pursuant to his appointment made on 19th of
September 2006 month.
19/9/2006. Full stop. In other words, the respondent number 5 has already spent more than
17 years.
17 years in service. Full stop. Therefore, considering the fact that it has been established that he is a better candidate on merit as compared to the petitioner, and having regard to the peculiar facts and circumstances of the case, this court is of the considered opinion that there is no justifiable ground for this court to set aside the impugned order dated 23/9/2011. Full stop. For the reasons stated herein above, this court is of the opinion that there is no merit in this writ petition. The same is accordingly dismissed. Mr. Nair, you tried.
No, can't have. This is an equitable order. It's the right thing.
Yes, that's what, in as much as it will be highly inequitable for this court to now set aside the appointment of the respondent number 5, only to let the department to take a fresh view of the matter. Full stop. Yeah, after 17 years.
In that concluding paragraph, 2 places it has gone as petitioner, while
Yes, yes.
it should be respondent number 5.
Respondent number 5, check it.
Much obliged.
All right,
My lord, I'm praying for listing of a IA day after tomorrow, my lord. What happened last Friday? A notice has been issued to the petitioner to vacate his official quota, my lord. So today morning we have filed, and 7 days time has been given. That is why Thursday they will proceed, my lord.
Yes.
Deeply.
Lordship, I furnish the copy extra.
Yes, same order may be passed, Lordship.
Same order.
Same
What is
order.
that order?
And more Lordship, in this case, my lord, when rejection slip provided, thereafter, my lord, one appeal was preferred.
Mr. K. Bhuya, appeal was preferred.
Lordship,
What happened to the appeal?
nothing acted upon, my lord. That is page 50, my lord. 50,
Page 50.
Lordship.
Let the appeal be disposed of then
Lordship.
within 4 weeks from today.
Lordship.
And my lord, his height is 165.5 centimeter. And wrongly recorded as 164. When he was,
Mr. K. Bhuya, learned counsel for the petitioner, also heard Ms. R. Devi, learned CGC appearing for the respondents. Full stop. Pursuant to the advertisement notice dated 27/10/2022, issued by the Staff Selection Commission, inviting applications for appointment of constables stroke GD under EWS categories in the Central Armed Police Forces bracket CAPF bracket
CAPFS.
for the years 2022. The writ petitioner had submitted his application and thereafter he took part in the selection process. Full stop. After undergoing the physical efficiency test bracket PET bracket close and the prescribed standard test bracket PST held on 9/5/2023. The petitioner was disqualified on the ground that his height was 164 cm, which is below the prescribed limit.
Prescribed is 165.
Full stop. According to the respondents, the candidates must meet the height standard of 165 cm so as to qualify in the PST.
Yes.
Full stop. Mr. Bhuya submits that the height of the petitioner is 165.5 cm and therefore his candidature has been wrongly rejected by the authorities on the ground of shortfall of height. Full stop. The learned counsel for the petitioner has further submitted that although his client had preferred an appeal before the respondent number 5 or 6.
Respondent number
5 and 6 vote.
Respondent numbers 5 and 6.
5 throw 6.
Respondent number 5
Throw 6.
through respondent number 6 on 10/5/2023. No order has been passed in the said appeal, as a result of which, the petitioner has been compelled to approach this court by filing the instant writ petition. Full stop. Ms. R. Devi, learned CGC submits that the grievance of the petitioner can be looked into in an appeal preferred before the competent authority. Full stop. Therefore, since the petitioner has already preferred an appeal, she would have no objection if a direction is issued by this court to dispose of the said appeal within a definite time. Full stop. Mr. Bhuya, learned counsel for the petitioner, has also agreed to such a recourse. In view of the above and as agreed to by learned counsel for both the parties, this writ petition is being disposed of at the stage of motion hearing by providing that the appeal preferred by the petitioner on 10/5/2023 be considered and disposed of by a reasoned order as expeditiously as possible, but not later than 4 weeks from a date of receipt of a certified copy of this order.
And Lordship,
With the-
one thing may be note, my lord, kindly. My lord.
Whatever be the outcome of the process, the same be communicated to the petitioner in writing. Yes,
Lordship, the measurement, height measurement also
with the above
by
observation.
by Superintendent of Civil Hospital
Stands this.
and
Well, they will look into all this.
Lordship,
Obliged.
highly obliged. Lordship.
36, 37, and 38.
Lordship, in this case, I'm appearing on behalf of Advocate General, Lordship. In terms of last direction, Lordship, we are supposed to file our affidavit, Lordship. But we are facing some difficulty because entire records, Lordship, is presently under CID's custody, Lordship. One CID investigation is going on.
Then file an affidavit saying that.
Lordship, in the meantime, we are communicating with them, Lordship.
See, Mr. Nayak, there
Lordship.
should be clarity on a few things.
Lordship,
The court is not blaming you,
Lordship.
but the court is finding it difficult to accept the logic. You have to file an affidavit saying that we can't file an affidavit. That also you have to file an.
No, right now we have communicated with them, Lordship. We are seeking the records.
What becomes difficult to accept when you ask the court to wait because some counsel is not there, some record is not available. This is not ethical.
Lordship, by the next date, Lordship, one affidavit I will file, Lordship.
You should not do it. Don't do it. You
Lordship.
can't ask the judge to court to wait just because it is not convenient. Something is not happening somewhere. You have to inform the court that these are the things, these are the records and so and so. Therefore, we can't file an affidavit till we get the record. The court will pass its orders.
Lordship.
You can't tell the court that give us more time, we'll file affidavit. That you can't say. That is not the way judicial proceedings
Lordship,
are.
one affidavit I will file, Lordship.
What do you say, Mr. Kaur?
If you had informed me yesterday, then I would have not come only. Your Lordship, I
That
can't.
you have to settle elsewhere.
Yes.
You know how.
Yes, sir.
We can't comment. Mr. B.D. Kaur, learned senior counsel, assisted by Ms. So and so, and Mr. N.J. Khatami. Mr. B.D. Kaur, learned senior counsel, assisted by so and so. Has appeared for the petitioners in item numbers. You are in item number 36 and 37.
Same item.
36 and 38 and 38. Whereas Mr. N.J. Khatania, learned counsel for the petitioner, has appeared in item 39. Give the case number. Mr. P. So Khatania for 37, Mr. Kaur for 36 and 38. Mr. P. Nayak, learned standing counsel,
Not standing counsel.
Then-
I'm assisting Advocate General, Lordship.
learned counsel appearing on behalf of the Advocate General of Assam, seeks posting of this matter again after 2 weeks, so as to enable him to bring on record the stand of the department by filing a short affidavit, including the submission that the relevant records are presently in the custody of the CID. Mr. P. Sharma, learned counsel is
Standing
present.
counsel.
Learned standing counsel,
Yes.
AFDC is also present and makes a similar request seeking time to file affidavit. In view of the above, let it go after vacation.
Yes, ma'am.
Yes.
Your Lordship will only give me kindly give me a fixed statement.
In view of the above, let these matters be listed again. In the 4th week of July 2023 on a non-miscellaneous date. In the meantime, affidavit on behalf of the respondents be positively filed.
May I pray it on 27th of July, my lord? First 2 days I may not be there. my lord.
27 July. Yes.
Deeply obliged, ma'am.
Obliged, Lordship.
Lordship, there is the last order.
Lordship, I'm,
160.
on last occasion, Lordship has directed us to,
Let him finish.
Lordship.
Lordship, may kindly peruse the last order, that is 1/6/2023. On that day, Lordship, we have made a statement that only, Lordship, the subsistence allowance have been paid in terms of page 51, 52, and 53. We have not been paid subsistence allowance from the date of termination, that is 2016. They have disputed that, Lordship, saying that we have paid. That is how, Lordship, the case is fixed today to obtain instruction whether subsistence allowance has been paid or not. We have given the, Lordship, at page 7, only page 51. Only these 3 money received we have given in our writ petition. And that has been paid from 1/1/2022 up to, Lordship, 1/10/31/2023. In terms of the earlier single judge order, Lordship, they are supposed to pay the subsidy allowance from the date of termination, that is 2016. That has not been paid. From the date of termination means? Where is the order? Let us see. 20, Lordship. Where is the order of Lordship, single judge? Lordship. At page, the relevant portion is at page 36, Lordship. The direction, Lordship.
It is, that being the position, this court directs as follows. The punishment imposed upon the petitioner by order dated 28/2016 is hereby set aside and quash. The respondent board shall start the proceeding de novo against the petitioner by issuing a fresh so cause notice on the basis of allegation of misbehavior threatening alleged by the then chairman, vice chairman, executive officer of the Borpeta Road Municipal Board. The entire proceeding shall be completed within a period of 6 months from the date of receipt of a certified copy of this order. The petitioner shall participate in the proceeding, and the petitioner shall not create any inappropriate situation during the departmental inquiry. The petitioner is hereby reinstated in service for the purpose of the de novo proceeding. However, he shall continue to remain under suspension during pendency of the departmental proceeding. The petitioner shall be entitled for the subsidiary allowance during such period of suspension. In the aforesaid terms, this writ petition is disposed of, however, no order as to cause. Thereafter, they have filed an interlocutory application seeking extension of time for another period, Lordship. That order, your Lordship will find at page.
So you will be entitled to subsistence allowance from the date of your reinstatement. When was your client reinstated?
I have not been reinstated, Lordship. That order has not been followed.
You have not been reinstated.
Lordship.
Lordship, that's I pray for 2 weeks further time, Lordship, in this matter. And Lordship, even though this is their Lordship, but the he shall continue. If your Lordship may kindly peruse the order, last page of the order, Lordship, and para 5, Lordship, hereby reinstated in service for the purpose of the de novo proceeding. However, he shall continue to remain under such suspension during pendency of the departmental proceedings. So there is no Lordship.
What is the order reinstating him in service?
Lordship.
Where is the
Lordship.
order? Reinstatement, order of reinstatement.
Lordship, that's why Lordship, I am just praying for before he starts, Lordship, I was seeking time
That's right, but
for
you have-
2
you have
weeks,
been praying-
Lordship.
Your client has been praying for times in the last 4 or 5 occasions.
2 weeks time, Lordship, regarding this.
He has to come. Who is the authority?
Lordship, may kindly reasonable time, Lordship, even if it's not 2 weeks.
No, he is playing around with the courts.
And Lordship, may
Regarding
kindly-
subsistence allowance,
Lordship,
Lordship,
Mr. Das, will you please take your seat?
Lordship.
and admittedly, Lordship, after passing of the, after passing, Lordship.
There is a categorical direction of the court.
Lordship.
What is the difficulty in implementing the court's order? And you are seeking time again and again. You think we are. here-
Lordship, regarding subsistence allowance, Lordship, admittedly, they also have admitted since January 22 after, because it was passed in December 21, Lordship. So 22,
The question is, where is the order reinstatement?
Lordship, I will
Where is
place everything, Lordship, and through my affidavit, Lordship. That's why I'm praying for 2 weeks time, Lordship.
No, we'll give you time till Friday, otherwise personal appearance. This is not acceptable.
Lordship, kindly
They are just playing around with courts order.
allow us a reasonable time, Lordship, even not 2
You
weeks.
see the last order.
Lordship,
Who is the officer who is responsible? What is his name?
Lordship, regarding this, I am appearing only for respond number 4, Lordship. The chairman, Lordship.
That's right. So who is the person who is responsible for not complying with the court's order? That is the question we are asking you. There is the order of the court, is it not?
Lordship,
That order is.
yes, Lordship.
What is the date of the order?
Lordship, the date of the order is
2012, 2021,
2012.
Lordship.
Page number?
Page number, Lordship, running page 25, Lordship. 23 onwards it starts, Lordship. And the
So
date
this
mentioned,
order is of 20th of December
2021, Lordship.
So nearly 1.5 years.
Lordship.
Where is the order of his reinstatement?
Lordship, I shall place it through an affidavit,
Heard
Lordship.
Mr. S.K. Das, learned counsel for the writ petitioner. Also heard Ms. M. Bhattacharya, learned counsel appearing for the respondent number 4, who prays for another 2 weeks' time to file affidavit. However, this court has noticed that despite the order dated 1/6/2023 passed in this proceeding, and notwithstanding the fact that there is no material produced before this court to indicate as to the manner in which the judgment and order dated 2012/2021 passed by the learned single judge in WPC number 1710/2017 had been
implemented in this case. Instead of producing the relevant materials, the learned counsel has been repeatedly seeking time on behalf of the respondent number 4. Full stop. Such practice on the part of the respondent number 4 clearly appears to be an attempt to overreach the court's order. Be that as it may, before taking a final view in the matter, on the request of Ms. Bhattacharjee, this writ petition is directed to be posted again on, give the Friday's date as a fixed item, so as to give her one last opportunity to place the stand of the department on record as directed by this court. We do it by Friday, otherwise we'll take very, very stern action in the matter.
Lordship.
Enough time has been given, Ms. Bhattacharjee. You go through the record, you will see it. The councils are changing, but every time it is the same thing. There is an order of the court to reinstate him 1.5 years back. Why that order has not been complied with till today?
It has been complied,
Where
Lordship.
is the document?
Lordship, I shall place
Place it.
show in it. Lordship.
Place that document on Friday.
Lordship.
Otherwise, we
Lordship.
will take
We
action
shall-
against your client. You
We
tell
shall,
him that.
Lordship.
We don't tolerate people
Lordship, we shall.
playing around with court's order. We don't appreciate that.
We shall,
If
Lordship.
you have any difficulty, if you want some accommodation, we are always accommodating.
Lordship,
But on Friday, unless an order is shown
Lordship.
and proper particulars are given about the payment of
Lordship.
subsistence allowance, you can expect a harsh order coming from the court. Yes, next matter, please.
Lordship. Need to apply, your Lordship.
Lord, this is Kabat case, my lord. Only name of CGC will be changed, my lord.
CGC is also same. Same.
Yes, also same. How many petitioners? One
One
petitioner.
petition.
Single petitioner,
HR Ahmed.
Mr. Ahmed. Disposed of.
Lodge.
Obligation.
Obliged.
Yes, employees of 34 employees of the sewerage board, my lord. They were handed over to Silchar Municipality Board. And they are not getting their salaries. My lord, from the month of June 21 to January 22 and from December 22 till date. No salaries. Your lordship was recorded on 6/4/23. Now, how these people will survive? Government has taken the decision that employees of the sewerage board, urban and water supplies board will be put to, handed over to Silchar Municipality Board. And accordingly, Silchar Municipality Board, my lord, has taken their service.
Lord, I have the instruction from municipal board.
How very well.
My lord, there is no clear feedback. So my lord, what I will request, my lord, 2 weeks time so that I can get the proper instruction.
That salary part, my lord, they will have to survive, my lord, otherwise how they.
Salary means, my lord,
sustain?
first handing over and charge, all these things will have to be completed. So let us see what is the position.
Well, additional, my lord, chief secretary, my lord,
See,
your lordship may-
Mr. Datta, problem is when it comes to the weaker section, economically weaker,
My
marginal.
lord, I
section,
understand that.
People seem to be, how will they feel if the officer's salary is stopped?
1 month salary.
How will they feel?
Definitely.
If the judges have now started passing this kind of orders. I saw it few days back.
The only thing, my lord, I want to clarify. Now, supposing, my lord, they are already been employed by the municipal board, they are duty bound to clear it up. Now, the fund will have to be given by the state. Now, what is the position, my lord, state will have to clarify that whether they have given funds for these
No,
employees are
who's
concerned.
for the state? What is this happening? These people have their families. they
Well,
have to support their
106,
families.
page 106, your lordship, can you see?
Page 106.
Yes.
Mr. Sharma, these people have a family to support. This appears to be a very casual approach. Somebody says they are handed over to Silchar Municipal Board. Silchar Municipal Board says, we don't know. How can this happen in a state apparatus?
Nobody seems to be knowing anything. Is it a new method of terminating services?
Lordship, that's true, but Lordship, I am also handicapped, Lordship. I have
Then
no
let the
instructions.
secretary come. Who is the secretary? Let him come and explain.
May I get some instructions, Lordship, in the meantime, Lordship?
That's why it was.
6/4/23 order, your lordship will kindly see. Detailed order has been represented. RMDS Learned Standing Council Assam Sewerage Board submit that a decision has been taken by the board to send a proposal to the government requesting for funds for release of all area salaries of all the employees, including the petitioner. Decision was taken on 61st board meeting held on 24/2/23. Mr. Das submits that once the government accepts their proposal, well, government has taken a conscious view that the sewerage board employees will go to, well, Silchar Municipality Board. That is at page 106. Handing over of Silchar water supply scheme from to municipality board. For the better functioning of so and so, the state government desires that all urban water supply scheme currently run by Assam Toll Supply and Sewerage Board are to be taken over by the respective municipality board. To that effect, and you are directed to make arrangement for taking over the Silchar water supply scheme with all man, materials and liabilities. Now next page, your lordship will kindly see. Executive Officer, Silchar Municipality Board. It is addressed to, with reference to the subject cited above, it is directed by government wide order.
These are what, these are regular employees.
Regular
permanent
employees, they were getting salaries, but
How
from
many,
the
total, how many?
34.
Instructions are not.
Last time they said, my lord, they have sent proposal to the government and government cannot sit over the matter, my lord. By just writing one letter that the Silchar Municipality Board will take over and not paying their salary. This is very irresponsible, my lord, on their part. They're very poor persons, my lord. Master role workers and all.
We'll grant you 6 weeks time. But next 2 months salary, the government will have to pay. We'll direct the chief secretary to make arrangements. This is not acceptable. In this today's context where prices are skyrocketing, how do you
Lordship,
expect these people to
Lordship, I
survive?
appreciate Lordship.
They are regular employees. They have families to look after.
The master role, they are working for a long time, since 1999, my lord. Work charge employees.
Master role employees, Lordship.
99, since 99, 2002, they were getting regular salaries, my lord. It is not that.
Their
services
16
are
years
different.
services works as khalasis in the aforementioned circumstances.
That is not a dispute, my lord. They are working, their services have been handed over to Silchar Municipal Board. While
Take
work-
a third, Mr.
May I
Peter
may I pray, Lordship? Lordship may fix it after 1 or 2 weeks, Lordship. In the meantime, Lordship, if you don't get any instructions, as because it's not that it is the lacking on our part also. The lacking is on their part also there. As because, Lordship, the case was moved on 6/4. We have to wait till the last of the after making some phone calls, Lordship, these copies were served upon us. That is also there, Lordship. Your Lordship must have to look into that also, Lordship. Otherwise, I would not have, Lordship. I should not have tell all these things to this honorable court. But we are also facing this type of problem. As because it's in my handwriting, Lordship, it is written on the top of the file. So
Right,
there.
take down, Mr. B.D. Das, Learned Senior Counsel for the writ petitioners, has invited the attention of this court to the order dated 6/4/2023, as well as 7/6/2023, submits that the petitioners herein were all serving as work charge employees of the Assam Urban Water Sewerage, Assam Urban
Water Supply and Sewerage Board.
and Sewerage Board. But by the notification dated 29/10/2021, their services were placed at the disposal of the Silchar Municipal Board. Full stop. Notwithstanding the same, and despite the observations made by this court in the order dated 6/4/2023, the petitioners are going without any salary stroke wages since Since June 21 to January 22, that is the service with the board.
January 22.
22 and,
thereafter-
and from December 22 till date, ma'am.
Thereafter, since the
December
month of
22
December 22,
till date.
2022 till date. First step. Mr. Das submits that the petitioners are facing extreme financial hardship due to non-payment of their salary, and therefore a writ of mandamus be issued upon the government to release their current salaries. Full stop. Mr. S. Datta, Lanet, Senior Counsel appearing for the Silchar Municipal Board, submits that there is no concrete decision yet taken by the government as regards the handing over of those employees to the Silchar Municipal Board, nor is there any financial provision made by the government for payment of their salary. Full stop. Mr. H. Sharma, learned additional senior government advocate Assam, submits that he be granted a week's time to obtain concrete information, concrete instruction, and place it before this court as to the steps that can be taken, immediate steps that can be taken for granting relief to the petitioners. First of, on the request of Mr. Sharma, this writ petition is directed to be listed again on 19th of June 2023 as a fixed item. A copy of this order be furnished to Mr. H. Sharma, learned additional senior government advocate for doing the needful.
Lordship,
Mr. Sharma, we have to pass.
Lordship,
your
Lordship.
order, Because.
I will try my level best, Lordship. I will try my
You
level.
understand the situation.
Yes, yes.
If these are matters that the courts cannot come to
Lordship.
the rescue, then
So I'm appearing for respondent number 3 and 8 on behalf of Mr. S.P. Chaudhary, Standing Council, Assam Urban Water Supply and Sewerage Board. We will file our
what
affidavit.
is your name?
Ms. B. Devi Lords.
Ms. B. Devi, Learned Counsel is present on behalf of respondent numbers 3 and 8 and prays for time to file affidavit. What about you? Mr. Nayak, you are there in this? Mr. P. Nayak, Learned SC Finance is present on behalf of respondent number 9. How are you?
I can call you.
Yes, please.
May I please your lordship? Matter was fixed for instruction, my lordship.
Lordship, we have received instruction, Lordship, and needs 2 weeks time, Lordship, file affidavit.
No, but what is your instruction?
Lordship. Lordship, there are many allegations against petitioner, Lordship. Lordship would like to peruse, Lordship.
Yes. But was any notice served upon her?
Lordship,
Huh?
it was Lordship.
Locus.
Yeah, Lordship, it was in that, Lordship. Should I flag mark it, Lordship?
Just a minute. Just- So let her file affidavit. They say that notice has been served.
Yes.
All right, heard Mr.
And
N. Islam, Learned Counsel appearing for the writ petitioner. Also heard Ms. A. Talukdar, Learned Government Advocate Assam, who submits that in terms of the order dated 8/5/2023 passed by this court, she has received instructions along with parawise comments and therefore be granted 2 weeks time to bring the same on record in the form of an affidavit. Prayer is allowed. Let this matter be listed again after 3 weeks. In the meantime, affidavit on behalf of the department be brought on record.
Obliged.
Deeply applies, Lordship.
Orders item 44.
My lord,
May I please, your
may I
lordship?
please, already completed.
Already complied. I am appearing on behalf of M. Bhagavati.
Heard Mr.
NH Borbia.
NH Burvia Learned Counsel for the petitioner will submit that order of this court has been complied with. Miss, your name, please?
B. Talukdar on
This B.
behalf of M.
Talukdar is
Bhagavati.
present on behalf of the
M. Bhagavati.
respondent,
All respondent.
all the respondents, and confirms the safe position. In view of the above, this contempt case stands closed.
File of.
Item 45.
Disposed of.
My lord, the order has been complied with.
Miss
Al Islam.
N. Islam, Learned Counsel for the petitioner submits that the order of the court has been complied with.
1 and 2.
Mr. N. Upadhyay, Learned Counsel for the respondent numbers 1 and 2, and Mr. P.
respondent number 4.
Learned Counsel for the respondent number 4 have also confirmed the safe position. In view of the above, this contempt case stands closed.
Okay.
46.
Who is appearing?
46.
Eight 2018. None appears to the petitioner on call. In view of the above, this matter be listed again after 3 weeks.
Item 47.
May I please, your lords. Lordship, in service is complete, my lord, in this case, my lord. As per my lord, Lozima Court order dated 7/6/2023, my lord.
Okay, Mr. F.
Yes.
Hazarika, Learned Counsel for the petitioner has invited the attention of this court to the Lojima Court order dated 07/06/2023 to submit that service of notice upon the respondents is complete in this case.
One.
I have perused the order of the Lojima Court, registered to this case for admission.
My lord. There is an interim order, my lord.
Interim order passed earlier to continue.
Deeply obliged, my lord.
Item 48.
May please, your lordship. My lord, here in this case, by order dated 31/2023, my lord, cost title has been corrected on 25/5/2023. My lord, implementing the respondent number 10. My lord, notice is not issued, my lord, to him. My lord. No notice.
All right. I am appearing for 7, 8, and 9.
So we'll issue notice on
My-
newly implemented. I heard Mr. Yar Sigdal and counsel for the petitioner. Also heard, Mr. Who is appearing for whom? Mr.
appear
S.
for-
Datta,
And for 1 and 3.
that is standing counsel, Revenue Department. For respond numbers 1 and 3, Mr.
I appear for 3 and 4. 4 and 5, 4 and 5.
Mr. P. Nayak, Learned SC Finance Department for respond number 2. Mr. D. Bora, Learned Government Advocate Assam for respond numbers 4 and 5. And Ms. N. Bora, Learned SC PNRD for respond number 6. Mr. S. Islam,
R Islam.
R. Islam, Learned Counsel is present.
7, 8, and 9.
For number 7, 8, and 9. Issue notice to the newly implemented respond number 10, making the same returnable in 4 weeks. Petitioner to take steps. by
My
Mr.
lord,
Post ready.
we may be, liberty may be granted to take those the service also. My lord.
In addition to the above, liberty is also granted to the petitioners to take steps by means of dusty for service of notice. Dusty to be routed to the registry of this court upon the respond number 10.
Deeply approved.
Item 49.
By order dated 19/4/2023, the lordship was pleased to get the relevant file from the
Irrigation Department. This is with regard to order passed by a secretary in violation of this honorable court order. This honorable court will set aside the minutes of the state level committee, directing the state level committee to freshly consider. And the secretary pass an order since the state level committee has already rejected. So therefore, there is no reason for consideration of this case again. That was the order passed by the secretary.
Lordship had directed to reflect the name of the irrigation department, Lordship, by the last order, Lordship. So I am here, Lordship.
Yes, what do you have to say?
Lordship, I don't have anything, Lordship.
Lordship wanted to get the relevant file from the irrigation department on the last occasion, because they have filed an affidavit saying that the Honorable High Court's order was overlooked while signing the order, because the note did not contain the Honorable High Court's order that was said in the affidavit. So Lordship wanted to verify that from the records.
All right, you give him a copy of the petition.
Lordship, yes.
You are for whom?
I'm appearing on behalf of our day.
For the contempt, Lordship, he is there.
For the contempt.
All right, I heard Mr. H.K. Das, the counsel for the petitioner, also heard Ms.
Shaheen.
R.
Shaheen.
Shaheen, counsel appearing for the respondent. In terms of the order dated 19/4/2023 passed by this court, this matter has been listed by showing the name of Mr. N. Upadhyay, Learned Standing Counsel Irrigation Department in the cause list. He has appeared before this court today. A copy of the contempt petition be furnished to Mr. Upadhyay so as to enable him to go through the same and produce the departmental record, which would go to show the circumstances under which the order has been passed by the authorities by ignoring the High Court's directives. What is the order dated? What is the order dated? Dated?
High Court's order dated.
Not High Court's order, their order.
This is Milord, 29 April 2015.
The order dated 29/4/2015 was passed by ignoring the High Court's order dated
2/4/2014.
2/4/2004.
In WPC number 1806/2014.
1806/2014.
2014.
WPC number 1806/2014.
Highly appreciated.
Well, here the claim of the petitioner was regarding arrear salary as well as, my lord, non-practicing allowance. He is a doctor otherwise. But regarding the arrear salary that has been paid, already been released to the
That has
petitioner.
been going on since long.
Yes.
What is the new point here?
Yes, well, regarding the non-practicing allowance, though he has made a claim before the honorable court as well as before the respondent authorities. Now we have come to learn that, my lord, no, he has not even applied for that particular, my lord, allowance. In 2023 now, my lord, when we pointed out in the contempt petition on 25/4/2023, he has now applied before the principal after his retirement in 2018. So it
So
cannot be a
consider
part
it.
of, yes.
Consider it.
Proposal has already been submitted by the Director of Medical Education to the government. But cannot be a
what?
part of the contempt now, my lord, because he,
Proposal for what?
for releasing that, my lord, non-practicing allowance.
So give it to him.
That will pay, my lord, because the proposal has already been submitted to the, my lord, government by the director. Is under consideration. That's why the delay, my lord. He has not even applied, my lord. Now he is applied when he.
He has applied when?
16th. My lord, on 16/4/2023.
Regarding
correct.
this, may I explain, Lordship?
Yes.
What happened is that for the sixth pay commission, only in sixth pay commission, this provision for non-practicing allowance was there. Previous fifth pay commission is not there. Seventh pay commission also it is not there. Only in sixth pay commission. So when the matter came up for this non-practicing allowance, the faculties were asked to give their
So
option.
that's all right. Now you have applied on 16th of April
Yes.
2020.
Yes.
We'll give them some time.
Right.
They've send it to the proposal to the government.
Yes, DME has already.
You are
submitted.
appearing for whom?
Well, here, for the respondent, my lord, in the health department, all are, my lord, from health department only.
Who has sent the proposal to the government?
But the Director of Medical Education has sent, my lord, forwarded the proposal to the government.
That is respond number?
DME otherwise is not a party respondent. But it is lying with the government, my lord.
All right, Mr. So-and-so.
Let it be posted
Dr.
at the end of
Basanto
my
Lashkar
July.
is present, personally present. Mr. B. Gogoi submits that after the application submitted by the petitioner on 16/4/2023, seeking non-practicing allowance, the matter has been examined by the directorate, and thereafter the Director of Medical Education has
Yes.
sent a proposal to the government
My lord.
for payment of non-practicing allowance in view of the above allowance. Full stop. Since the issue of non-practicing allowance was not a part of the original prayer in the writ petition.
The prayer was
No,
there,
a
my lord.
part of
He has
the-
not applied.
Huh?
He has not applied for that, my lord.
Acha. Since the petitioner had not applied for non-practicing allowance at the time of filing the writ petition,
At the time of his service, my lord, he retired in 18.
Achha.
During his service, he has not,
during the period of his service,
my lord.
hence some time be granted
Yes.
to process his application. The prayer appears to be reasonable. Full stop. Although this is a contempt proceeding, yet taking note of the facts and circumstances of the case, more particularly the stand of Mr. B. Gogoi, appearing for the respondents that a proposal has been sent to the government
Right.
for release of the amount of non-practicing allowance in favor of the petitioner. This matter is
After the vacation, my lord. Let me
Yes,
after.
is adjourned till 26th of July 2023, by which date the learned council shall obtain concrete instruction and place it before this court as to the status of the application submitted by the petitioner for release of non-practicing allowance. Such instructions be obtained in writing from the
Right.
competent authority.
Let's say, I had actually applied in 2008, but they cannot find my application after so many years. It is not possible for them to find out my application after this 15 years.
All right, now they are processing it. Have some patience, have some patience. Yes.
God bless.
Item 52.
Yes, what is this?
May I plead, Your Honor, I for early hearing of WPC number 4720/2014.
You want early hearing?
Lordship,
When?
Lordship,
Tomorrow?
July,
Tomorrow?
Lordship,
Huh?
Lordship,
Or day after tomorrow?
Lordship, day after tomorrow.
All right. Your name, please?
You Hazarika,
Ms. U. Hazarika, Learned Counsel is present on behalf of the applicant. His IA has been filed with a prayer for early hearing of WPC number 4720/2014. I peruse the same. Mr. P. Nayak, Learned Standing Council, PWD Assam, submits that he would have no objection if the prayer is allowed.
Just
In
one,
view of-
Lordship. Lordship, this is a petition of 2014, Lordship. My affidavit is already there. He is claiming promotion to the post of section assistant. And at that point of time, he was working as handyman. In my affidavit, I have stated that his next promotion will be driver. So she should obtain instruction as,
That we'll see.
just
We'll have
that in the
Thursday.
meantime, Lordship, if he has got any problem.
With regard to the ground on which the prayer is made, same stands allowed. Registered list WPC so and so for hearing as a fixed item on Thursday, which is, give the date, 15th of May. IA stands disposed of.
obliged.
And there will be no adjournment.
Lordship,
The final order will be passed on 15th. Come
Lordship.
prepared this way, that way. Yes.
May I plead your lordship? In
Yes.
this case, notice was issued, my lord, and I have taken statement of that. Up to the respondent number 6, by through register post. And
Lordship, I have received the instructions. I can place the respond number 6, there was a select list and the respond number 6, Mrinalini Deka, she was selected, serial number 2. And the petitioner is serial number 1. There are only 2 selectees, the select list.
Petitioner is serial number
1. Sandana Das,
and Mrinalini Deka is 2.
respond number 6.
Then what is the
selected.
problem in the writ petition?
but the petitioner was not yet selected, my lord. His name is not in the select list, my lord. What, But here the petition, in the advertisement.
Who has been appointed?
Respond number 6.
6 has been appointed. And the petition,
Mrinalini Deka.
but without following any oral interview.
How it was done? If the petitioner was the number one, then why number?
No, petitioner was never the number 1. Respond number 6, she has got more marks. There is a spelling mistake. She has written Sandana Das in this select list Chandana Das. That is the only difference. Let me file a detailed affidavit. I have received the rest of the instructions, Your Lordship. I'll file a detailed.
But
affidavit, Your Lordship.
the petition has been filed because in the advertisement, there is a eligibility criteria. The selection process will be held through oral interview. But no interview was initiated. The petitioner is not even called for the interview. Suddenly the select list was published, my lord.
No, that is.
But-
Let him file his affidavit.
Yes, my lord.
All right. Heard Ms. Bujar Burwal, Learned Counsel appearing for the petitioner, also heard Mr. D. Bora, Learned Government Advocate Assam, appearing for the respond numbers 1 to
1 to 5.
who submits that he has received instruction and therefore be permitted 2 weeks time to file affidavit. Prayer along, let this writ petition be listed after the affidavit is filed by the official respondents. Please.
Please, Your Lordship. Lordship, in this matter, we are awaiting instruction, Your Lordship.
Mr. Khalid,
Let him file.
let him file. How much time?
Fixing a date, Lordship.
Lordship, 3 weeks. Your Lordship.
Fixing a date. You fix it.
As per convenience, Lordship.
You fix.
Last.
Heard Mr. J. Kalika, Learned Counsel for the petitioner, also heard Mr. R. Gogoi, Learned Standing Counsel Forest Department Assam, appearing for the official respondent, who prays for another 3 weeks time to file, obtain instruction and file affidavit. Prayer allowed. On the request of the petitioner's counsel, let this writ petition be listed again on
17 or 18 July, Lordship.
You
Immediately
fix.
after 17 July. Lordship.
17 July
Yes.
2023.
Yes.
That's a fixed item. Affidavit on behalf of the department be brought on record in the meantime.
Obliged, Lord.
Please, Your Lordship, this matter, I have challenged the imping order dated 21/11/2018, Lordship, whereby it was directed that the petitioner has not been entitled for area salary from the date of his discharge until the date of his reinstatement, Lordship. And
Lordship, may kindly peruse last order of this honorable court, Lordship.
So you have implemented Superintendent of Police Dharam.
yes,
There is an order to implement, is it? Bringing on record Superintendent of Police means what?
yes, it is, I have challenged the impugned order is also in the terms of this 1740 writ petition, this tag with this. And so page number.
So anyway, what is your instruction, Ms. Talukdar? What is your instruction?
We don't have the IA, Lordship. Implement
What it is.
in the records. We don't have it.
All right, we'll implement the Superintendent of Police. There is no need for IA. We'll
Lordship,
implement it today. You obtain instruction.
Lordship.
Heard Mrs. Chakraborty, Learned Counsel for the petitioner, peruse the order dated 15/5/2023. Passed in this proceeding, whereby the petitioner was directed to file appropriate application so as to implement the Superintendent of Police,
Yes,
Dharam.
already implemented, Lordship.
No
This,
formal
this
notice has been-
petition is the 3095 of 2023, Lordship. The superintendent of police is also the,
Writ petition,
it is the new writ petition, is there?
what is the number of the writ petition?
Two number of writ petition, is the earlier writ petition 1740, Lordship.
This is 1740 only, Lordship.
Yes, 174, but this is the 3095 writ petition, Lordship. The last, it is the stag with this writ petition, Lordship.
But in the causal that is not there, Lordship.
Cause list.
Something is wrong, Ms. Chakravarti. Only
Lordship.
one writ petition is here
Only one is there.
and the order is passed in this writ petition.
Yes, Lordship.
Yes, Lordship.
You have to do all these things in your chamber.
Yes, Lordship.
So,
This is the only last orders I have prayer is that this is the repetitions and earlier is the repetition 1740 is tagged with this repetition.
No, it is
And the
not
what
tagged.
12/6 2000
There is no such order. Which order?
the repetition 3095 Lordship. And
That-
here
That matter is not. before
order
us.
is also there.
What is it written? Complete.
This petition.
However, I find from the record that no such application has been filed. Be that as it may, taking note of the nature of grievance expressed in this writ petition and for ends of justice, the superintendent of police, Dharan, Mangaldoy is hereby implemented as respond number 4 in the instant writ petition, registry to make necessary endorsement in the cost title of the writ petition. First up, Ms. Talukdar accepts notice on behalf of the newly implemented respond number 4 and prays for 3 weeks further time to obtain instruction on behalf of all the respondents, facilitating disposal of the.
This tag with this petition Lordship, tag with the writ petition Lordship, 3095,
They are
it is the
allowed.
same petition.
However, on the request of Ms. Chakravarti, this matter is directed to be listed along with WPC number.
WPC 3095 of 2023 Lordship.
3095 of
23 Lordship.
2023.
And here is also implemented also,
It is
superintendent.
stated to be analogous to the present proceeding.
Deeply obliged, Lordship.
For hearing. Item 55.
May I please?
My lord, on the last occasion, my lord was pleased to
WPTBC.
include WPTBC as a party, my lord, in this matter. My lord, problem is now WPTBC, that department doesn't exist. There is a bifurcation on this last June. This almost now a year. And this now, it's a two department. One is tribal affairs, the other is social justice and empowerment. OBC and ST has gone to them. I have written a letter to them. They are trying to trace the file, my lord, of this anything. They said that they need some time. Because I have written to, I am the standing counsel for tribal affairs. I have written to them on 29th. So yesterday, again, when I called, they said, we are trying to locate the thing. You pray for some time so that we can give you some instructions. That is my thing, my lord. Without any instructions, my lord,
You wrote your prayer through proper channel,
I-
Mr. Nair.
My lord, I can't object.
my senior will not object.
Otherwise, the prayer will be rejected.
My lord, my senior knows.
Mr. Nair
My
knows what
difficulties-
happens when it
my
is not through
difficulties-
proper channel.
My senior understood my difficulty, my lord.
What do you say?
Fine, let him have some time, because
Then
this
let him
matter has
go
to be
after
trusted
vacation.
immediately on reopening, madam. Or 2 days, 3 days, madam.
I heard Mr. UK Nair and senior counsel instead by Mr. S.U. Ahmed Learned Counsel, S.U. Ahmed Learned Counsel for the writ petitioner. Mr. R. Dhar Learned Standing Counsel.
Tribal affairs.
Tribal Affairs Department has appeared for the newly implemented respond number 11 and submits that the Department of WPT and BC has been bifurcated since past 1 year by creating two new departments, that is the Department of Tribal Affairs and the Department
Social justice and empowerment.
Social Justice and Empowerment. First of, the present matter would come within the domain of the Department of
Most
Tribal-
probably my social justice.
Social Justice. And so whatever it is, so and so. However, since it is an old matter and the file is not traceable, and the departmental authorities have prayed for 3 weeks' time to seek instruction. Full stop. Since the prayer is not opposed, same stands allowed. Let this matter be listed again in the 4th week of July 2023 as a fixed item.
Lordship.
Mr. Dhar to in the meantime obtain necessary instructions facilitating disposal of the lead petition. Mr. For
Much.
hearing. Huh?
Much obliged.
May I please, your lordship? Lordship,
Yes. So your clients are aggrieved by the cancellation of the earlier selection process.
lordship,
The earlier selection process cannot go on now. 2008 selection process cannot be given effect to now. Whichever way you look at it,
no. Here, my lord,
there has to be a fresh advertisement today, whatever be the circumstances. That's the law.
no, since the matter is pending since 2008 itself, my lord.
Hmm.
And this, the interim protection was also granted by this honorable court. And this is continuing, my lord. And
Mr. Chetri, you argue your case, but I'm telling you the law and how this matter will be governed. There are umpteen number of decisions of the Supreme Court also, which says that the selection process has to take into account the factor that in the meantime, the vacancies have increased number of new applicants have come in. So advertisement notice issued in 2008 or 2007. That cannot be today given effect to, whether it has caused prejudice to your client or not, regardless of that. So today, if the appointment is to be carried out after the gap of more than 15 years, there has to be a fresh advertisement. That's the law.
now problem is this, my lord. Since they are now over it, now they cannot apply.
That part we can take.
No, now around 45, 46, my lord.
Hmm.
And now they cannot come back and say that now we are will appear and that will be considered. Someone are 47, 48 like this, my lord.
Who is for the department? Hmm. What is this? This has been pending since 2008.
My
What
lord,
has happened to these vacancies? What has happened to the 10 vacant posts of junior accounts assistants?
This still vacant, my lord, because this honorable court has protected the petitioner's interest, my lord, by passing the appropriate order.
What is the appropriate order?
Lordship will find.
Order dated?
Order dated lordship. I have enclosed this honorable court's order here, my lord, in another petition. 57 to 60. Lordship will find at order dated 12/12/2008. Cancelling this the selection, the new advertisement was issued, my lord. Issue notice so and so, so and so, so and so. In the meantime, and until further order of further step pursuant to the impugned advertisement annex 6 to the repetition shall remain suspended.
Yeah, that is what Mr. Chetri, please try to understand.
Lordship.
After all, the clients are something, but you are an officer of the court. If the impugned advertisement is set aside today, that doesn't mean that advertisement will revive. There's no such law.
No, subsequent, my lord, since here, my lord, only that part was there in second writ petition, my lord. I have also challenged the impugned cancellation order, my lord, without issuing any notice, without giving any opportunity of hearing. That impugned the notice was issued, my lord, cancellation order. And my lord, to that effect, my lord, that on the tips of the minister, that order was issued, my lord. And lordship is very much aware.
Your clients were selected.
Yes, and my lord, I have also gone through the when matter was argued before the honorable court, my lord. I have been permitted to go through the record of the government, my lord, and I have noted down. And on the basis of this affidavit, this record, my lord, I have also filed an affidavit, my lord, saying and there was no irregularity, no illegality in the reflected in the order itself, in the office record itself, and only on the instruction of the irrigation minister, the irrigation minister, the commissioner issued the impugned cancellation order. That cannot be, my lord. Since lordship is aware about the decision of the Supreme Court that on the instruction of the minister cannot be issued the cancellation, my lord. And when and lordship is also aware that when the person's right is adversely affected, my lord, the opportunity has to be given to the persons. And this the Honorable Apex Court also clearly said that once person's right has been adversely affected, he must be given the opportunity before passing the impugned order, my lord. That has not been done.
You're right. You're absolutely right. But the problem here is the select list is of 2008.
My lord, I understand, but only
We pass an order asking them to take appropriate action. Beyond that, there
No,
cannot be a direction to implement this.
no, only my grievance and my prayer before lordship is this. Since I was on the expectation that the cases will be considered and accordingly it will be the petitioner would be benefited, my lord. Now they are overaged, my lord, around 47, 48. Now what the lordship has thought that in case he or she may be allowed to participate in the selection by relaxing age, my lord, had there been only 38, 30, 40 like this, my lord, then 40 the matter is different, my lord. Now 48, 49 they are reaching, my lord. On only that part, my lord, probably unless your lordship will consider, my lord, otherwise the petitioner will not be benefited, my lord. They will be out to kill, my lord.
They will be out.
They will be out. That is why, my lord, this is the problem. Otherwise, I was quite with your lordship's view, my lord.
So now, Mr. Chetri, see, the problem is, the
Now,
court has full sympathy with your client. But the legal position has to be respected. By delay, your clients have missed the bus. That's the long and short of the matter. Nothing can be done now.
I leave it to your lordships on this.
So
matter
why don't you
only-
suggest
only-
something which is legally permissible? I'll do it.
My lord,
Leaving it is not going to help.
since-
You tell me by showing an authority that this order can be passed. I'm willing to pass an order. If you can show me the way, I'm willing to
No,
pass an order.
since, my lord, only in the case, my lord, only since I have filed an affidavit, lordship may go through that particular affidavit. On the basis of this, the government record, my lord, the affidavit has been filed. Lordship will find in that.
I am setting aside the advertisement,
No, not
correct.
only,
But there cannot be a direction to
No.
give you appointment as per that
my
select
lord,
list.
not only that, my lord, apart from this advertisement, my lord, I have also challenged this impugn the cancellation order.
Correct. That will also be
Well,
set aside.
If it is cancelled, my lord, or if lordship will interfere, my lord, then the matter will come, my lord, since the selection list already been prepared.
It
is-
cannot be, it cannot be. It cannot be because
Then
there is
it
no
go-
interim order keeping the select list alive. Interim order is only to suspend
No,
the
my lord,
advertisement.
since, my lord, not only that, my lord, the interim order for advertisement. And
Anyway,
another, my lord,
you complete your argument. I have told you what is the legal issue. If you have an answer, I'm willing to consider.
but otherwise, what the lordship has thought it, my lord. But otherwise, this petition would not be
I'm
beneficial.
saying I have my sympathies
tell
with your
you-
client.
Otherwise, either lordship will say the matter is in fructus, or
It is
you will not get
It
any.
is in
those-
structures.
lordship.
It is in structures. 15 years have gone by now.
No, but I respectfully submit, my lord, it's not my fault, my lord. It was pending, my
No,
lord.
no, Mr. Chetri, the question is not of fault or no fault.
Lordship,
The court is sympathetic to your clients,
lordship.
but something which is not legally permissible, this court cannot pass that order. You have to show me that without extending the validity of this list, how this list prepared in 2008 can be given effect to today. Show me that judgment. I'll pass that order.
Regarding validity,
Yes.
lordship.
Fault or
Somewhere-
no fault, I don't
some-
know, but you have not got an order from the court that pending disposal of this writ petition, the select list will remain valid. That order is not there. That order should have been there. After 15 years, a list which has expired by efflux of time cannot be given effect to. That's the law.
Somewhere, I may be wrong, my lord, I'm sorry, my lord. Somewhere I have found, my lord, on the day of validity, when the writ petition is filed, my lord, then there cannot be a expiry of the validity.
Show me the judgment.
Lordship.
Where is the judgment?
Yes. Not today, my lord, that since the lordship has said, my lord, that, but I will.
Yes, Mr. Dhar, what is your stand?
My lord, I was just trying to look for the judgment, my lord. That government, that regarding cancellation of the, my lord, process, recruitment process, my lord. Government may cancel, my lord, recruitment process at any point of time, my lord, if there is a cause, my lord. And my lord, yes, even my heart goes out to the petitioners, but my lord, it's now 15 years, almost 2008, and now it is 23. In this 15 years time, my lord, it's a huge, my lord, time gap. It won't be, my lord, even.
Say something new. This is what the judge has already said. Say something new.
My lord,
Mr. Chetri, you do whatever you want to do. On Thursday, I'll take it up, but
No, but
difficult.
that,
We
but I will satisfy your lordship, that what
You do
lordship
it,
has said.
satisfied, but a select list of 2008 cannot be operated today. That's the law.
No, that the
That
extension
is,
period.
unless there is a specific order saying that this will be kept alive until further orders or something. Otherwise, it creates a right in rem of other selected candidates. Anyway, you may not be able to agree to
Some-
this right now.
No,
but that's
somewhere
the-
I may find, my lord, to handle your lordship, my lord.
You do it. You can't handle me. You can handle my query.
I'm sorry. my lord.
Handling
To-
me will be
to-
little difficult for you. You can handle the query, but Thursday
Lordship,
or day after tomorrow, day after.
day after tomorrow. Can it be on Thursday, Lordship? I will get the time. my lord.
Thursday.
Huh?
Last two occasions, petitioner was not there.
None
Lordship.
appears for the petitioner on call. The petitioner's counsel was absent even on the two previous occasions during the last week when the matter was called up. So says Sharma, Lani Standing Counsel,
Health
Health
Department.
and Family Welfare Department, Assam is present. It appears that due to long lapse of time, the petitioner is no longer requested to pursue this matter before this court. As such, this petition stands dismissed for non-prosecution. What is this IA? What is this IA? Is it live?
Item 7.
Lordship may it please this. The petitioner was a retired civil service officer of 1980 batch, Your Lordship. He retired from service on 30/11/2010, Your Lordship, as Joint Secretary, Tourism Department, Government of Assam. Lordship, his grievance is that while he was in service on the allegation of issuing some citizenship certificate, Your Lordship, he was placed, DP was drawn up, which has resulted in awarding censure, Your Lordship. So then thereafter, Your Lordship, which resulted in awarding censure, private respondent, Mr. Kamal Losan Goswami was given promotion on 2 occasions. I filed representation before the authorities why my case was not considered. But as on date, nothing has been done. In the meantime, Your Lordship, I retired from service, Your Lordship. I retired on 30/11/2010.
Yes.
They have filed their affidavit, my lord. Lordship, may I take your lordship first to the my select list, annexure 1 of the writ petition.
So what is your prayer, Ms. Bhuya?
Lordship, notional benefit to be given to me with effect from the date the private respondent was given promotion. Because he was all along junior to me, your lordship. And rule says, your lordship, rule doesn't say anything as regards promotional avenue. But OM of the lordship government of Assam says, during the department proceeding, a person, if awarded with censure, he cannot be given benefit. But his promotion be considered on the next DPC. But admittedly, your lordship, when the private respondent was given promotion, your lordship, it was after I was awarded with censure, your lordship. DP was lordship initiated on, your lordship, kindly note the date, 27/7/09. And 3/11/2009, DP was closed.
27/7/2009.
Yes.
Yes.
And it was closed on 3/11/2009, your lordship,
Yes.
which has resulted in censure. But after that, your lordship, the private respondent was given promotion, my lord. Annexure 6, my lord. 16/12/2009, pro forma respondent was awarded promotion to officiate the resident secretary. And thereafter, your lordship, to the rank of secretary on 9/9/2010. I have annexed all the orders. The lordship will kindly see annexure 1 of the writ petition, my lord. At page 10. My name appears Deepak Kumar Goswami as serial number 22. Lordship, the name of the pro forma respondent is Kamal Losan Goswami as serial number 24.
No, Ms. Bhuya, I've really not understood your case.
Yes,
Now, he is a officer of Assam Civil Service
Yes.
Class 1.
yes,
Then what happened? There was a DP initiated against your client
yes,
on 27/7/2009.
yes,
And it was closed on 3/11/2009.
yes,
By imposing censure.
yes,
Correct.
yes.
Now, the private respondent number 6.
Yes.
That is one Kamal Nasan Goswami. He was promoted to which post?
Additional Secretary on 16/12/2009, Annexure 4 to the writ petition.
1612, and this person was junior to your client, junior to your client.
Yes,
But your client's case was not considered.
yes. On 2 occasions, this person,
Just a
lordship.
minute, just a minute,
Yes,
just a
I'm
minute.
sorry.
16/12/2009 is the date of promotion.
Yes,
When
first
was the
promotion.
DPC held? When was the DPC?
DPC was closed, lordship on,
No, not departmental proceeding, departmental promotion committee.
that instruction I don't have, but the private respondent, when he was given promotion,
Hmm.
I have got the date, my lord. It's 16/12/09, Annexure 4 to the writ petition.
All right. So if there is a censure,
Yes.
then the promotion cannot be considered in the
Yes,
immediate
du-
DPC.
No, yes, during the department process, drawing of department process, that period, it should be kept in seal cover.
Hmm.
But even in the next DP, in the Department Promotion Committee meeting, his case should be considered as per the office memorandum of the government of Assam, which I have annexed.
Which is the annexure?
Lordship, reply affidavit of mine, your lordship, which I have filed on 31/10/2011.
Reply affidavit. is it?
Yes, my lord. Annexure 1, page 6. May I read you? Lordship?
Just just a moment. (17/10/2008) is
Yes,
1987.
Yes, my lord.
All right.
May I read, my lord?
Yes, please.
Page 6. The undersigned is directed to invite a reference to the government office memorandum dated 6/7/1776, 1976, laying down the procedure to be followed with regard to confirmation, promotion of officers when they are under suspension or departmental proceedings are pending contemplated against them. The following further instructions are issued for guidance of all concerned to deal with matters when promotions are to be considered in case of imposition of minor penalties like censure, withholding of increments, and recovery from the pay of the whole or any part of pecuniary loss caused due to negligence or breach of orders of the government. When the department proceedings have been ended with the imposition of a minor penalty like censure, recovery of pecuniary loss to the government, withholding of increments of pay, and withholding of promotion, the recommendation of selection committee in favor of the employee kept in the seal cover will not be given effect to. But the case of the employee concerned for promotion confirmation may be considered by the next selection committee when it meets after the conclusion of the departmental proceedings. If the findings of the selection committee are in favor of the employees, he may be promoted in his turn. If the penalty is that of censure, recover the pecuniary loss caused to the government by negligence or breach of orders. In the case of employees who have been awarded a minor penalty of withholding increments or withholding of promotion, promotion can be made only after the expiry of the penalty. Since my case covers, because I was.
Just a minute,
Yes,
just a
madam.
minute. So this penalty of censure was imposed on 3/11/2009,
Yes.
correct?
Yes,
So the DPC which was held immediately after that, your client's case could not have been considered.
yes,
Right?
my lord.
So when was the immediate DPC after that? What is the date? of-
Lordship, I don't have the instruction. I have got the order which was passed in favor of the private respondent regarding promotion, my lord.
Right. So this 16/12/2009 shows
Yes,
that there was a DPC held,
yes,
but you don't know when the DPC was
yes.
held.
I do not have
Right.
any instruction.
If
On-
that DPC was held prior to 3/11/2009,
Yes,
then it will have one effect.
yes,
If it was held after 3/11/2009,
yes,
then that would mean in the next DPC, your client's case has to be
yes, my
considered.
lord.
So when was the next DPC held?
Lordship, 16/12/2009 was the first promotional order
Hmm. The
wherein my case.
promotional order and DPC are two different.
I had
things.
two different aspects, the order, and thereafter one more promotion order was awarded on 9/9/2010, Annexure 6 to the post of secretary.
So your client was working as what at that point of time?
My client was working as Lordship Joint Secretary Tourism, and they have filed an affidavit. They have given promotion to me as additional secretary after filing of the writ petition, a retrospective effect on 28/3/2011.
On 20?
8/3/2011. Retired on 30/11.
when did he retire?
30/11/2010, my lord.
So during this period, 3/11/2009 to 30/11/2009, during this period, if any DPC is held, Departmental Promotion Committee, Lordship, in that case, the petitioner's case is to be considered during that period.
Was it done?
Lordship, we are facing one difficulty, Lordship. That query was made to us, but we have lost somewhere our file. We have reconstructed it. And as because Lordship, only day before yesterday, I think Lordship, the letter is sent. But may I suggest, Lordship? May I suggest, Lordship? If during this period, 3/11/2009 to 30/11/2010, if any DPC is held, then as because because of this memorandum of 1987, that after the censure Lordship she is entitled to, her case may be considered by, his case may be considered, Lordship. Within the, by that direction, I think.
Mr. Sharma, I appreciate your stand, but this kind of, you see, amorphous writ cannot be issued. Writ can be issued only when the court comes to a specific finding about the right.
Lordship.
If it is done, then do it. If it is not done, then do it. But if it is something in between, then do that.
Lordship,
That kind of writs cannot.
No,
be
no,
issued.
Lordship, as because I'm suggesting as because it's a case of 2010. In that case, Lordship, I have again have to make a prayer, Lordship, as because it's fault on our part. We have misplaced the file
That's all
somewhere.
right, it happens, but see, ultimately court orders must solve problem, not
Lordship.
create more problem.
That is why, Lordship,
Creating problem for her client or for you is.
as because
no-
it's just she's praying for a notional benefit, Lordship. Notional benefit is,
No, all depend on was there any
Lordship,
right
but-
to be considered. If there is no right, matter else there.
Lordship.
If there is a right, then it has to.
That
be
is the instruction we have to,
Yes.
got that during this period, any DPC was held or not.
Yes. So just because if it takes one more week, that doesn't mean we pass
Lordship,
an order.
Let it produce a record.
Lordship, I have already sent the letter also, Lordship.
What
So-
we'll do is we'll take it next Tuesday.
Lordship,
Keep it as part of your.
This is a part two matter.
in the hearing. In the hearing, this,
You call it next Tuesday.
Lordship,
Please try to find out.
Lordship,
Then we'll pass a clear, definite order,
Lordship,
this way or that way,
Lordship,
so that it doesn't create more confusion.
Lordship.
Lordship, let them be directed to produce the records.
No, he will.
If that instruction we get, Lordship, as because I have already sent the letter, if that instruction I get, Lordship, that will sufficient, I think. And if any doubt arises, in that case, Lordship will produce the record at that time.
Yes. In any case, your client is
Lordship,
retired. It's all
Lordship.
about some financial benefit.
Yes.
That's all.
You still keep it on?
The council is not there. Which matter, parties, both sides ready? Yes, Mr. Goswami? Which is your
Mine
case?
is item 13, but I don't see the respondent counsel. Otherwise, I was ready. In fact, in his presence on the last week, your lordship have said that your lordship will take it.
Who is the council for the
Mr.
respondent?
Das, S. Das. I can inform him, your lordship may have it tomorrow. Give him a call to them.
Mr. Dev Chaudhary, you are,
Worship, item number 10, but I am told Mr. Majumdar is out of station for his child, so he's in Delhi. If it can be taken up after 2-3 days, maybe he'll be back.
Majumdar means?
R. Majumdar. He's not back. He's gone to Delhi for some, something, Mr. Lordship.
All right.